But we are praying for listing a motion matter. We have filed on yesterday. Can it be on Friday? And another one is hearing matter. Matter of 2022. Can it be on 1st of May?
No, you list it for orders. Will be on 2nd of May. Let it come for orders. We'll see.
Hearing
Hearing matter it can't be mentioned. It have to be mentioned for orders, for fixing a date for hearing.
Lord, at least the back to mention one restriction for admission matter. Pertains to appointment in the BSF, some similar persons have already adjusted in some other departments.
2nd May.
May I please, Your Lordship, with the consent of the petitioner, I beg to mention item number 44. Lordship, in this matter, I am appearing for respondents, Lordship. Lordship, today we have some difficulty on our part, so Lordship, may I pray to take up this matter after 1 week?
44 at the request of council appearing for the respondent stands adjourned for 2 weeks. It's submitted council consent. You have taken consent.
Yes, Lordship.
Consent of the council for the petitioner has also been obtained.
Item number 33, Your Lordship. I'm for the respondent bank. With the consent of the other side, Lordship, I'm praying for an adjournment today.
Lordship, I am appearing for the petitioner, Lordship.
Yes.
Here we have also filed an IA, Lordship, which has been registered as 1273 of 2025, Lordship. That may also be tagged with the
Item 33 at joint request stands adjourned for 2 weeks. It is submitted by council for the petitioner that an IA has been filed in the matter, being IA number
1273 of 2025.
1273 of 2024. Proper registry will list the IA along with the writ petition after 2 weeks.
Lordship, may I pray for fixing a date, Lordship?
There is a date fixed today.
Lordship.
You agreed to an adjournment.
Lordship, because
Then-
there is an IA also.
So you let it come after 2 weeks on a date will be picked by the registry.
May it pleases Your Lordship, with the consent of the other side, I beg to mention item number 22, Lordship. Lordship, kindly matter may be fixed after a week, enabling us to file affidavit in opposition. We are for the respondent, Lordship.
22. Who's for the petitioner?
I'm for a
22 matter be listed after 2 weeks, 3 weeks. You are filing what? Affidavit.
Affidavit, Lordship. We
How
have
much time do you require?
1 week will be
1 week, all right. Least after 2 weeks. Date is fixed today. You agreed to an adjournment. Let it be after 2 weeks. Make a mention if matter is not listed, you make a mention.
deeply obliged.
Thank you, Lord. Lordship, I have a small request in regard to item number 8. We have filed an affidavit in opposition where there's a small typographical error, where I inadvertently mentioned respond number 1, filed on behalf of respond number 1 as respond number 2. I may be allowed to correct that.
In the presence of the court master.
Lordship, I am taking listing here, Lordship. Last it was listed on 25/10/2020. Thereafter it has not been listed.
For
orders here.
For order. 2nd May.
If I have to pay for speaking of the matter.
2nd May.
Please, Lordship, I'm praying for listing of a hearing matter. Matter pertains to
For orders, 2nd May.
for admission, my Lord,
On?
On 28.
28, why?
Or any other day.
2nd May.
May it please Your Lordship, I beg to mention a writ petition for admission next week, any day.
Not next week, let it be on 2nd May.
Like,
My Lord, not on 5th May. My
5th May. Okay.
Yes.
Yeah.
Lordship. If I beg to mention for one motion matter, it was last listed on, my Lord, 24/5/24
For 24/5/24.
for obtaining instruction.
Then
Still it's not
why have you remembered it today?
some urgency is there.
Urgency. After 1 year.
May it turn 20.
30th.
I am the
Photo.
in this case, I was supposed to file affidavit, Lordship, but my officer is in election duty in April
Hmm?
2nd. He's in the election duty, Lord. So he will be coming on 15, Lord. But MD is the only authorized person. No officer are also there in AFDC. Employees are sorted, Lordship. So after 15 May, Lordship.
What is the matter here? What is your
The
grievance?
person retired on 31/12/2021. Lord, I am yet to get my gratuity, then leave
Lordship,
encashment
here-
benefit. All these things hasn't been paid yet.
Yeah, lot of facts are there, Lordship, because he has already signed an affidavit while being reappointed, that he is admitting all his guilt in 2021. We got it only later on, Lordship, after filing of the affidavit.
My lord, the board of directors has given a clean sheet. Now, whether the new things can be brought now.
No, the board of directors has, that is the fact, Lordship. That file was missing, where board of directors indicted him, and he has confessed that he did the wrong thing. So that fact should be brought in.
Well, Lordship-
Everything is ready, Lordship. Affidavit is ready.
When can you file it?
After May 15, Lordship.
Why?
He is on Hailakandi, Lord. No officers are there in AFDC, Lord. All employees
You
are.
have to just file an affidavit.
Who will sign, Lord?
Do we have to tell you how affidavits are to be signed?
No, MD is not there, Lord.
The MD is there, you call him, get the affidavit signed and file it.
In that case, Lord, let it be in second week of
This is
May,
a
Lord.
very ridiculous submission you are making
Lord,
after 15
No,
May.
no, Lord, because officer is on election.
You are the counsel. You know how affidavits are being executed in court. You have to advise your client.
That is true, Lord.
Is it the other way around that your client is advising you what to do?
No, Lord, the fact is that he is in Hailakandi for too long.
Mr. Counsel, do we need to spell it out to you how affidavits are to be signed?
That I know, Lord. I have
Then if you know, then why are you making this
Lord, then
submission that after 15th of May, it will be convenient for him to come down and sign? We are not inviting him to file an affidavit. You sought liberty to file affidavit, we are giving you time.
that is not the second week of May, Lord.
The second week of May,
Lord,
you file it by 9th of May.
that will be better. I will ask him to come down, Lord.
I don't know what you want to do. You
No,
file
I
it
will
on.
do, Lord, because we are having problem in corporate, Lord. That's why we don't have staff for.
Your problem, you handle your problems.
Lord,
But-
in this case, Lord, Fishery department is also willing to file the affidavit.
Hmm?
Fishery department is
You are
also
representing whom?
both,
Both.
Lord.
Then you file affidavit on
Lord,
by both.
I will file Parawise document, but notice was not.
All right, we issue notice then. Third Learned Council for Party. Okay. That was on 9th May. Respondents are permitted to file their affidavit. In the meantime, if they comply. List accordingly, since Mr. Sharma represents the respondent, notices are waived, however, extra copies be furnished within the course of this week, if not already furnished.
Public.
Okay.
Yes.
My lord, an arbitration petition, my lord, on the last occasion, my lord has my lord, asked for the amount which is exact amount figure, my lord, which the department is entitled. My lord, page 117 is the amount, my lord. Page 117, if my lord will take. That is the risk and cost, my lord, 25,44,152. And my lord, how this figure has been arrived, my lord, that I have taken instruction, my lord, for subsequent to the honorable court's order, my lord. My lord, I am placing that.
You bring it on record. If it is relevant, you bring it on record. File an additional affidavit, bring it on record.
My lord, I can.
Pursuant to the earlier order dated 21/3/2025, Mr. Gupta, Learned Counsel representing the petitioner, submits that he has received his instructions. He would like to bring it on record by way of an affidavit. Additional affidavit, placed accordingly.
Obliged.
May please, your lordship. Lordship, contempt petition, lordship. Lordship, the order is the page 30, lordship, and extra 7.
Right, issue notice. Returnable 4 weeks. Step on respondent by registered post 80 as well as usual courts.
Obliged.
Please, Your Lordship. Lordship, in this matter, non-compliance of order it is 6.
Have you seen the last order?
Yes, Lordship, I have seen. I have gone through the already pre-4 2024. Honorable Court has disposed of this matter.
No, what is the significance of the memorandum?
Yes, Lordship.
In view of the memorandum,
Yes.
whether this order can be now complied with? Can we
No,
direct the
Lordship, this-
respondents to comply with the order?
Lordship, this matter already disposed of on 3/4 2024. Lordship, I can place the judgment, Lordship.
Please place it
Lordship, after some time I can.
next week. Bring it next week.
Obliged.
Monday. Matter be listed on Monday, enabling the learned counsel for the petitioner who submits that the judgment of this court in a matter where the memorandum was challenged.
Yes, Lordship. 18/9
Memorandum dated
2024.
18/9/2024, issued by the state respondent, was put to challenge from the creative of the court to place the said judgment before the court on the next day. It's place taken on Monday.
Obliged.
Page number 27. One time.
Issue notice returnable 4 weeks. Steps on the respondent by registered post equal courts within 1 week from today.
Obliged.
There is some typographical error in the age of the petitioner. Their age are 54 and 52 respectively. It has been in as certainty written as 41. Otherwise, if the cover case, similar case has been disposed of.
Hmm?
If the cover case, otherwise, some similar matter has been disposed of.
What is the issue?
That the petitioners are temporary workers under the establishment of executive engineer test school. Division and that in pursuance to the order passed in football from a case, the government has formulated a policy. In pursuance to that policy, they are to consider their cases.
What age do you want to correct?
On affidavit page, affidavit page and cost title. On page 3,
Page 3.
Page 3.
Then?
Page 3, the petitioner number 1 is about his age should be 54 years.
54 years.
54 years. And therefore, petitioner number 2 is 49 years.
Why have you given the wrong age?
I apologize for any inconvenience.
You file a proper application for correction. Counsel for the petitioner will file a proper application. Necessary correction, which according to the writ petitioner has kept into the writ petition at the time. They made allowed it for the after how much time you require?
2 weeks.
2 weeks. The night for the respondent. PTC respondent. PTC. PTC.
May I please? This is actually covered by the judgment of this honorable court, my lord. And so,
Compassionate.
Yes, sir. The OM has been put to challenge and that the common order has been passed.
What order has been?
Because us to consider those cases which had been already ordered by this honorable court earlier occasions.
No, my lord, that is not exactly the fact, my lord. The state has given a concession, my lord. The Advocate General has, my lord, made a statement before the court that those matters are pending as on, my lord, the date of order of the court. That is 3/4/25, my lord. Only those cases, my lord, for one time, my lord, the SLC will consider. Nothing on merit. The matter was not, my lord, the order was not passed on merit, my lord. The OM was,
The consent order.
yes, consent order, my lord.
Then?
My lord, only the thing is that here what we need to, my lord, is verify is that whether the matter was filed before
It was filed on
3/4/2025. That is all, my lord.
registered on 11
If, my lord, the matter is filed before 3/4/25, then it is covered. If it is not filed, my lord, then it is not covered. Because this order will not become a precedent. That is what the order says, my lord. This cannot be treated
So
as
this
precedent.
order, 3/4/25 is with regard to the writ petitions.
Yes, my lord. That is what, my lord, in para 10, my lord.
Yes, para 9.
Para
the case is
9 and 10, my lord.
Yes.
registered.
Consideration is with regard to the writ petitions pending today, pending on that particular day.
Pending. Yes, my lord.
Then what? How do you interpret this in so far as this writ petition is concerned?
That is what, my lord. That is what I am submitting, my lord. Since this matter is, my lord, filed before that, so it will be covered. Because, my lord, no, why I am on this, my lord, now my lord will come across many cases today only. People are coming with.
No, but this is a very ridiculous interpretation you are giving. All writ petitions means you want all people, only those people whose writ petitions are before this court, they will get benefit. Somebody who is unable to come before the court, you will not consider their benefit. What is it?
That is what my lord's order says, my lord. This is
No. I don't think that is the interpretation that can be granted, that can be given. How many writ petitions are there?
This is only one. In that case, series of writ petitions.
Series of writ petitions. So it is those writ petitions which were pending on 3/4. Their cases are to be considered.
exactly, my lord. That is what I am also saying, my lord.
Therefore, I am asking you, how do you interpret this vis-a-vis this present writ petition?
These present writ petition covered because this was filed before 3/4.
Was it listed on the same day before the court? This matter.
It was
This matter was
not listed, but filed numbered.
Have you challenged this memorandum here?
Yes.
Where is that memorandum?
My lord, page 39.
If my lord wants to, my lord wants to take this on merit, my lord, I am ready to argue the matter. This OM was not touched, my lord. Or, my lord, this matter is in motion, my lord. My lord, if you notice, will file an affidavit. That will be far better, my lord.
Pursuant to the direction annexure A of the Honorable Division Bench, my lord, and the case of the petitioner was processed. And before convening of the meeting of the SLC, my lord, this OM has come. That is the hairstyle of petition. Meeting means what left. Meeting means what this thing. Condo. I don't know.
Learned counsel for the parties. This writ petition is filed by the petitioner, the OM dated 18/9/2024 on the grounds and reasons mentioned in the present petition. Where counsel for the parties have placed before the court an order passed by the court in bench dated 3/4/2025, whereby a series of writ petitions, similar writ petitions by challenging the OM dated was challenged. And on a consent order, the writ petitions were disposed of with certain direction. The directions are expected as below. Expect para 9, para 8, 9, 10, or you can say para 7, 8, 9, 10. It's para Mr. R. Ford, under additional senior government advocate, submits that they are agreeable to a similar order that has been passed by the court and bench, and undertakes and submits that the department will consider the case of the petitioner by taking into consideration various guidelines prior to 1/4/17 laid down by the state government, read with the judgment of the apex court as well as of this high court. In that view of the matter, without issuing notice that the state court considers it appropriate to dispose of the writ petition, since the counsel for the parties are agreed that similar directions can be issued to consider the case of similar directions can be issued. Accordingly, the respondent are directed to consider the case of the petitioner without taking recourse to the OM dated 18/9/2024. Your order was, your case was rejected. Your
It was,
case was rejected.
Earlier rejected,
When?
thereafter, my lord, 10 to 2022.
Page number?
Page number 30, my lord. The lord will find the earlier round of litigation. It was honorable single bench dismissed, my lord. Thereafter, division bench allowed it, my lord. Page number 33 is the order of the division
Was
bench.
that order set aside?
Yes.
Was set aside?
Set.
Then?
Then, my lord, direction was given to the government to place it before the SLC.
And where is the order of the SLP?
SLC, my lord, has not placed it till now. That is it.
In the facts of the present case, the case of the petitioner was earlier rejected by the SLC, and the state rejection order was challenged before this court, and in writ appeal number 332 of 2023, by order dated 7/9/2023.
Page 36, my lord.
The rejection order of the petitioner by the SLC dated 10/2/2022, read with what is 2/8/23,
It is a judgment of the Honorable Single Bench.
as well as the order of the learned single judge came to be reversed and set aside. So thereafter, the matter was not placed before the SLC in view of the impugned OM dated 18/9/2024. So accordingly, in view of the order passed today, the SLC, the respondents will take all steps to place the matter before the SLC, and the SLC will thereafter consider the matter in terms of the directions contained in this order without taking reports to the OM dated 18/9/2024 and appropriate orders thereon.
My lord, without taking the report of the impugned order, but my lord, there is a rider in the last order, my lord. That part, my lord, is
Which rider?
that impugned order dated, though the judgment provided therein, that is Devrati var supra, can be considered. That is there, my lord, in para 10, the last part.
Not necessary. Not necessary. The judgment of the apex court, it has to be considered.
Yes, my lord. Deep level.
Please,
Yes.
my lord, the other side, they have filed one affidavit, my lord, in this case. We need to counter to that, my lord. We need 3 weeks time.
Notice issued.
Notice not issued.
A notice may be issued.
Notice may be issued, Lord.
Heard Mr. S. Dr. Leonard Senior Counsel assisted by and MS M. Hazarika, Senior Group, assisted by Mr.
D. Khanula.
Khan, hearings for the respondent. The respondents have filed the. You are questioning the maintainability.
No, we are his claim, Lordship. Basically, he says this is what I have done, and actually,
So you have filed an affidavit in opposition.
Yes,
Yes. Oh no, position.
You have filed an affidavit in opposition, and the counsel for the petition takes liberty by rejoin the affidavit. So, according to the court is of the belief that notice required to be issued. The notice returnable 4 weeks. Since the respondents are represented, notices are waived. Extra copies, if not already served, be served in a period of 1 week. Petitioner is at liberty to file the reply affidavit as prayed for. List accordingly.
Obliged.
Madam, may kindly peruse the order dated 8/4/2025, 8 of April.
Yes.
Instructions or notice was not issued because instructions were sought for as to what.
Lordship, although the proposal was forwarded by the Labor Commissioner Office to the department, Lordship, and the representations of the petitioners were also forwarded to the department, but Lordship, the department has sought 6 weeks time for submission of the instruction in this matter, Lordship, from the department. So we require some time at least, Lordship.
My lord, we should notice that my lord, what has happened here? They are delaying the whole process. Now, if my lord comes to Annexure 2 at page 14, this is the recommendation. This list in which all the names of the 8 petitioners are there. This recommendation for consideration of promotion was sent on 6/12/2024. 4-5 months have passed. There has been.
Why is it not considered?
Lordship, because of this pendency of another writ petition, although Lordship, DPC has not been held, Lordship.
That is misleading the court. You must read your file before coming. My lord, these writ petitions were filed by people. Now, my lord, to put the thing in a proper perspective, there's a rule which says we are all ministerial staff. The rule says I have to complete 10 years in service and I have to be below 45 years of age to be able to be considered for promotion to the post of labor inspector. Now, we fit the criteria. Recommendation has been sent by the labor commissioner to the government in December. It's just sitting over it. The writ petitions that my learned friend has referred to, my lord, these people have crossed 45 years of age. So they come to the court seeking relief, but the court has sent them back saying they filed representations before the appropriate authority to consider your prayer to take a call or a change in policy that the relaxation of 45 years period.
We'll give you 2 weeks further time.
Yes, Lordship, those representations, whether they are considered or not, whether any DPC
Not on
has
that.
been.
You have to get your instructions that why you have not acted on the recommendations here.
Lordship.
Page 14.
Lordship.
What is your stand in respect of these recommendations?
Yes, Lordship, although we have communicated, Lordship, they have sought for some time, Lordship, to furnish us the instructions.
We'll give you 2 weeks.
Lordship, I'll have my instructions, Lordship.
Mr. R. Sharma, Learned Senior Counsel, assisted by MS P. Fupat, and Mr. MS U. Sharma, Learned Government Advocate. Government Advocate Kapit renews our prayer for completion of the instruction, as she has not received the same as yet. She prays for 2 weeks further time. Considering that the instructions would be necessary in the matter stands deferred to be listed after 2 weeks, by which time the learned government advocate will complete the instruction. It's after 2 weeks.
Notice may be issued.
Notice, then it goes beyond 2 weeks.
I know. We'll wait until 2 weeks, man.
Can you get it by 2 weeks?
Lordship, although they have sought for 6 weeks time, Lordship, I'll pursue them.
Why 6 weeks?
Lordship, this is only my instruction, Lordship.
Well, after 2 weeks, we'll see.
It may not, a date may be fixed. 7th.
9th February, 9th May.
9th. Obliged.
Highly obliged.
I will not. Matter parting regarding selection and appointments of the Kauvra matter. The advertisement dated my lord 3/9/2022 issued by the Bobata.
The Kauvra appointment is when? Bench 5. It's 3. Appointment.
And my lord, as per advertisement, petitioner along with the respondent will appear and interview held, and the petitioner was selected. When the petitioner was selected, my lord, the private respondent approached this honorable court for challenging his selection. This honorable court disposed the matter at the motion stage and directing to file an appeal, and in meantime, no appointment shall be made, my lord. So the petitioner approached the division bench challenging the single bench order. The division bench set aside the single bench order and allowed the petitioner to directed to the petitioner to appoint him. And in meantime, the appeal shall be heard. In meantime, my appeal was heard, and the appeal was allowed on the ground that, my lord, when the appeal was passed, the petitioner will join the post of the Gaura. A deputy will pass an order, and accordingly, petitioner join in post of Gaura. And subsequently, my lord, the matter was heard by the respondent number 2, and the appeal was allowed on the ground that the petitioner have no land. In the at some time, my lord, the private respondent, my lord, who is the elder brother of the petitioner, and he was not requisite qualification, my lord. He is not matriculate, my lord. As per notification 10/12/2018, and the notification, my lord, the petitioner must be issued.
What is the appellate order?
Appellate court order must be 44, my lord.
What is the finding here?
Finding on the ground that, my lord, at the last part, my lord, the petitioner has no land, own name, my lord.
Who is the petitioner? The petitioner means
The
present
petitioner as well the respondent, my lord. Petitioner and respondent are the brothers, my lord.
No, who is the appellant before the appellate authority?
My lord, the respondent number 6, my lord. Respondent number 6, my lord.
Yes. Your brothers.
Brothers, my lord. I was selected, my lord.
Hmm.
Because he was not, my lord, eligible, my lord. He not meticulous, my lord. And the order it is reflected, my lord.
So we should notice at this stage.
My lord, I have filed the caveat, my lord.
You have filed a caveat?
Yes, ma'am.
Caveat what?
What happened, my lord? My learned friend, my lord.
Caveat, I get it, Learned counsel for the caveat. Caveat discharge. Yes.
My lord, kindly turn to the page 26 of the petition, my lord. Page 26, my lord, they specifically mentioned the candidate should have clause 7, my lord. Page 26, clause 7, candidate should have landed property, movable property in her name in the area on which the intended to be appointed as Gav Pradhan. Accordingly, my lord, the present petitioner, my lord, submitted application as per the advertisement, my lord. What happened, my lord? When he had no any land property in his name, but fraudulently, my lord, and misleading the official authority, saying that my father is already expired, and his name was inherited, my lord, as a legal here, page 49, my lord. The finding of the land of director, my lord. Page 49, I am relevant portion I am reading, my lord. My lord, the LRA concerning plot of land measuring 21 bigha, 1 kata, 13 lesa, covered by Dag number Sponsu, annual pattern number 12 of village Alapati and C, under Bagbar Moja was recorded in the name of Abul Hussain, that is the father of the both petitioner and the respondent. They are the own brother, man. And further, as per order of Dad and Circle Officer.
Who is the Gampura now?
My lord,
nobody, my lord.
Nobody.
Father already retired, my lord.
All right, so we'll issue notice today.
My lord, my lord, I am charging is Gahura, my lord.
No, my lord.
To this
Already
date,
set aside, my lord.
Yes, set aside the, as per appeal order, he was set aside, my lord. But
and
division,
Mr. S. Dotto, appearing for revenue, 1 and 2. MSM Bhattacharya for 3, 4, 5. Mr. Anuddin for respondent number 6. Issue notice. 4 weeks since the respondents are represented. Notices are waived, however, extra copies be furnished within a period of 1 week from today.
interim prayer will be considered, my lord.
Issue notice on the interim prayer, returnable on the same day. List again on. Twenty-third May.
Well, father is LI. My
No, that
brother,
was done by my elder brother, my lord. That was done by my elder.
That
At
is
that
that,
time,
my
he
lord.
was in such
Showing in the circle office that my father is already expired.
We'll
inherited
hear
his
you.
name.
Yes,
Now
my lord.
land is
It was
cancelled.
done by elder brother, my lord. I am
No, but
younger brother.
but your
And he was-
appointment has
Already
been
set
set aside
Yes, my lord.
by the appellate order,
Yes, my lord.
which was passed on 17th of March.
No appointment. Selection was set aside, my lord.
Not selection.
Yes,
Yes, my lord. Rightly, the order has passed, my lord.
Selection, the order of appointment.
Like
See the last line. Order of appointment was
Yes,
set
ma'am.
aside. When were you appointed?
My lord, as per division's order, my lord. My lord, kindly see.
My lord, in division bench, my lord, it was not the order on merit, my lord. The division bench said that you file the appeal before the appellate authority what will
41, my lord.
find, they will pass the order.
All
And
right,
division bench order kindly
we'll hear you after let the respondents also file their response in the meantime.
I'm filed the
We are issuing notice on the interim prayer to consider on the next returnable.
Hello.
I'm blessed.
Lovely.
Yes, Mr. Paul.
Before Lordship, my lord, he was working as a deputy registrar of cooperative society, man. And way back in 2018, my lord, your lordship, enacted 4 page 27, a so-called notice was issued to him under Rule 7 of the Assam Disciplinary Rules, man. And he participated in a said proceeding by filing his WS, my lord, on 2021. That is enacted 7 page 38, man. Inquiry proceeded, my lord, witnesses were examined, and subsequently inquiry report was submitted. That was forwarded to your lordship will find at page 50.
My lord, the matter pertains to cooperative department, my lord, and their name is not shown in the cause list, because they have to represent, my lord. I don't think, my lord, copy was served to them. MD Bora and Mr. Bordoloi, they are like standing counsel.
Copy not served.
Copy.
Their name.
Copy was served, my lord.
Without being served, how the filing can proceed?
Copy was served, my lord.
It was served to the office of the GM, my lord. One copy was served, my lord. But it is the matter pertains to cooperative department, my lord. They have to be here. MD Bora, Moiri Bora, আৰু Gunjan Bordoli, G Bordoli, Janak.
What is the stage of the inquiry?
Now, what is about your lordship kindly particular situation? Inquiry report was submitted, 2 charges were not to be proved. 2 charges were found to be not proved.
How many charges were there?
5 charges. And so for the rest of the charges, there was no definite finding. So I filed my representation under Rule 9A, which was forwarded to me. I filed my representation. Now, inquiry officer, now the disciplinary authority, my lord, said about the matter, directed inquiry to allow me to cross-examine the witness. How did this possible, my lord? When the inquiry was already concluded, inquiry report was submitted. Your lordship, if you know your lordship, take last line, my last part. That
Page
is
number
108, Annexure 6.
Yes.
The additional chief secretary to government of Assam discuss in details of cooperative department in the inquiry report of the department proceeding against so-and-so, this petitioner, which was submitted by the inquiry officer, which was received by the department on 29/6/2025. Copy of the inquiry was forwarded to the DO for submitting representation by letter number so-and-so. DO has raised objection. He has never allowed to cross-examine matter by the inquiry officer by letter received in the department dated. Subsequently, letter was issued to the inquiry officer to hold further inquiry to cure the defects in the inquiry report. Whether that is permissible or not, my lord. When he has already come to a finding, my lord, how either he has to accept the finding or he may go for de novo inquiry. There is no provision in the disciplinary bill to cure the defect in the inquiry, my lord, after submission of an inquiry report. If any letter so-and-so, in response to notice so-and-so, inquiry officer has attended the hearing, so-and-so, did not attend the hearing, file letter number so-and-so.
All right, you find out your counterpart.
Oh, anyway, my you will have a picture there. I will try to furnish a copy to them.
All right, Monday.
Monday, yeah.
Let matter be listed on Monday.
Absolutely illegal order.
Mr. Kotoki, counsel for the petitioner, submits that he will ensure service of copy on the standing counsel
Cooperative
of
department.
cooperative department. It's accordingly on Monday.
Monday, yeah.
Here petitioner is a candidate having good academic career. One advertisement was issued on 7/2/2023 by the state level police recruitment board.
Today we can only issue notice.
On the 27th, result is going to be declared of the written test.
Right.
I was allowed to sit only 30 minutes. What happened,
No. What order you want today?
Thereafter, Bhaiva will be, they will conduct the Bhaiva.
So you have not cleared the written.
No, written, I was allowed to only 30 minutes.
Right.
2 hours.
Your
exam.
claim is that you should be allowed to sit in a written test.
Or considering the performance of the half an hour, because otherwise, if
So you wait for the result. If you want consideration of your half an hour's attempt of the written test, you wait for the results to be declared. We'll issue notice at this date.
Perhaps there is 2 different advertisements. So it was a condition in the advertisement that a candidate cannot generate multiple ID. But here case is that 2 different advertisements.
two different admit cards.
What do you want now?
Lordship will issue notice at this stage.
So third Learned Council for the parties issue notice returnable 4 weeks. MS M. Bhattacharya appears for all the respondents. Therefore, notices are waived, extra copies be furnished within a period of 1 week from today.
Some observations.
Respondents may complete their instructions and file necessary affidavit.
Lord.
What observation?
I have an interim prayer to stay the procedure.
Issue notice on the interim prayer.
Yes, Lordship.
Returnable on 23rd May.
Obliged, Lordship.
My lord, this is also compassionate appointment case, my lord.
You are challenging the same order?
Yes, my lord. My case was, my lord, some extent, in fact, this honorable court has directed the DLC and SLC to consider my case. This honorable court earlier, my lord, directed the DLC to consider my case because earlier it was not considered. Then it was considered by the DLC, my lord. Now it was sent for SLC. In the meantime, this notification.
So he was never placed before the SLC.
Yes, due to this notification, it was kept pending.
He was not considered by SLC.
Not considered by SLC. My lord, only the thing is that
This matter, my lord, was filed on 8/4/25 after that order, my lord, and that becomes a precedent, my lord. That is their, my lord.
8/4.
No, 8/4, my lord.
What?
Every order, every judgment becomes a precedent. Even if we say it is not a precedent.
My lord, that is the specific direction of this honorable court.
No, but it has to be accepted as a precedent. It is an order of the court.
My lord, that is what this order says. It cannot be treated as precedent, my lord.
My lord, even though, my lord, one more aspect, my submission is your lord may accept it or not. Because there is an order of this honorable court.
All right, we'll issue notice then.
No, my lord, your lordship can dispose of that.
Issue notice returnable.
One
Because this is there's a very cryptic order.
No, your lordship may kindly
On the
no, what happened, my lord?
on consent it was passed.
Yes, on third it was pending. But what happened, my lord? Especially this OM was not silenced, but there was a prayer that my lord, this OM may not affect the my lord petition because there was an order of this honorable.
No, if the respondent agreed that it can be disposed of, it disposed of.
Yes, your lordship may kindly say.
Saying that
then on next
the order itself says
my lord, your lordship may,
only matters
yes,
up
yes.
to
Let me submit, my lord, on page 21, my lord. Page 21, your
My
lordship
lord,
may
I am just on the order, my lord.
The order says 3rd of April.
3rd of, and it is filed on 8.
No, it was it was pending on 3rd. What happened, my lord? On 3rd, it was pending. On the next day, it was listed in the report.
No, my lord, filing date is 8.
No, your filing date is 8.
Yes, that is correct, my lord. Page 21 kindly may be seen, my lord.
21.
What happened? There is a development in this case, my lord.
Yes.
This case was on 5/4. It was withdrawn because it was in the writ petition. It was not specifically silenced that OM matter.
Then it was not covered at that point in time.
Yes, that point of time it was pending, and then only, my lord,
in terms of the earlier order passed by the coordinate bench, these are matters where specific challenge is made to the OM, and it was pending on 3rd. In your writ petition, which came to be disposed on 5th.
5th, it was pending on 3rd.
But you did not challenge the OM.
OM I challenged, but there, my lord, my prayer was that in that case, my lord, that my lord,
But you withdrew the writ petition.
Yes.
And there is a
with the consent of the other parties, my lord.
There is a finding, there is a observation that you want to withdraw and file a press assailing the OM.
Yes, assailing the order. There was no assailing because, my lord, our prayer was that, my lord, that OM, what my submission was, that OM will not come into effect to the petitioner because
we'll examine the matter then.
This case was already, my lord, considered by the
we'll make it returnable by 2 weeks. By 2 weeks.
My lord, it was 3 weeks, my lord. We file affidavit of it.
We'll have to examine this.
No, one aspect your lordship may kindly see why I am saying, my lord, on 5th, on 3rd the case was pending.
their case is that, my lord, the case should be pending on.
But that matter is withdrawn.
Yes,
At your
with the,
prayer.
with the consent of the other side.
Yeah,
Right, my
whatever
lord.
it is withdrawn. This matter was not filed on 3rd.
And second aspect, my lord, second aspect, what my submission is, my lord, if your lordship may kindly see the OM also, my lord, for the time being, my lord. OM has not said this.
We will examine that.
Yes,
that aspect. We'll examine that aspect. That is what we are saying. Third learned counsel for the parties issue notice returnable after 3 weeks. Mr. R. Dhor, learned counsel. Government advocate, additional senior government advocate, appears on behalf of all, and as such notices are waived, extra copies be furnished. Huh? Appears on behalf of, so MS D Neog appears on behalf of 1, Mr. Dhor on behalf of 2 and 3. Therefore, notices are waived, extra copies be furnished within a period of 1 week from today. Right. Matter be listed after the returnable date. We have given returnable 3 weeks. Yes, after 3 weeks.
Obliged.
Notice today?
Yes.
Heard? Huh? All right, you'll serve it. Third, learned counsel for the party. Issue notice returnable 3 weeks?
4 weeks.
4 weeks. 4 weeks?
No. I am for respondent 3, 4, and 5.
Mr. N. J. Gogoi for respondents 3, 4, and 5. MS. So appears for respondent number 2. And U. Sharma for 1. Since the councils have represented the respondents, notices are waived, extra copies will be furnished within a period of 1 week from today.
So item 20 is the same.
Same?
Same.
Item number?
20.
20. All right.
Obliged.
Same order.
Obliged.
14 and 20.
Good morning, Lord.
Yes.
Lordship, the facts of this petition is that I was appointed in the office of the Assam State Housing Board as an LD assistant in the year 1992. At the time of my appointment, Lordship, I had only one document to show my date of birth, and that was the high school living certificate issued by the principal of my school, Jorhat Government Boys Higher Secondary School. That it is annexer 4, Lordship, page 22. So that I submitted that certificate as a proof of my age, because at that time I had no other document. But I noticed that in that document, Your Lordship, my date of birth was mentioned as 1/11/66. It was a handwritten entry, Your Lordship. Then I noticed that this date of birth is not correct, Your Lordship. My actual date of birth is 2/11/1969. According to my LP school certificate and all the documents. Then I applied in the school to correct my date of birth. But Your Lordship, in the 1992, when there was a devastating flood.
You have superannuated. You
Yes.
retired from service.
Are
you still working?
Yes, Lordship.
You're still working.
I'm still working, Your Lordship. I'm still working, and I have later on I have got the birth certificate from the village headman, and then I got the PAN card and the Aadhaar card from issued by the government authorities, and those documents are I have annexed as annexer 7, 8, 9, and 10, Lordship.
What orders you want today?
Lordship, my date of birth, I have applied to.
You want your date of birth to be corrected.
Lordship.
Let us give them an opportunity to come get their instructions on in this regard.
Yeah, Lordship.
We'll issue notice today.
Yes, Lord.
Heard council 3 weeks. You are appearing for both. You Sharma appears for respondents 1 and 2. So therefore notices are waived. Extra copies be furnished within a period of 1 week from today. Matter be listed after the returnable date. respondents may complete their instructions and file affidavit in the meantime. After 3 weeks,
May it please the Lord. But if a petitioner was engaged, then it after worker by order page 17, my lord, with effect from 15/5/2015. Lord, till date, our monthly remuneration.
yes,
not paid.
Take instruction, my lord.
get your instruction. Third counsel for parties, MS A. Bora will obtain instruction. Representing
Number 2 and 6.
respondents 2 and 6, we will obtain instructions as to why the salary, remuneration / salary in respect of the writ petitioner. Salary of the petitioner has not been released with effect from May 2015. Para MSD Bora, it is for 134 and 5. List according. Although notices have not been issued, extra copies be furnished. They pick their obtain the required instruction. List according.
Date may
21st of May.
May. I'm
Yes.
The matter relates to the transfer of the petitioner, who is the caregiver of a differently able dependent. He serves in the 30 Assam Battalion in a 30 NCC Assam. Lordship should have the policy which the respondents have. For a moment, at page 24, the first office memorandum. There earlier to this, but here, my lord,
He is
Lordship will find.
Where is he posted?
My lord, he is posted now here at Narangi. He is being transferred to Jaisalmer.
Where is that order of transfer?
Yes, Lordship would find that order.
Page 52.
Page 52. 20 when his son was hospitalized. His certificate, Lordship would find it 2 pages before. At page 50, my lord. That is of 10th of. Otherwise, the other tests were done prior to that. The autism was detected on or about 14th of January. Immediately, my lord, he placed a representation, Lordship would find at page 53 onwards. Page 54, para 10. He made a request as per the policy for both the parents to be registered under the policy of the respondents themselves, along with the child, so that they can avail posting together for the benefit of the child. At page 54, para 10. This was done, my lord, on, if Lordship finds on the next page, 24th of January 2025, which was recommended by his commanding officers. Simultaneously, Lordship will find at page 61.
Yes.
His wife, who is also serving here at Narangi in the army, had made an application, similar application. There at page 62 of the application, the second paragraph, para 9, I am reading, my lord. I am due for posting out the army through policy letter number so-and-so as legislative foresighted and emphatic policy of officer with differently able dependent. I request you to register me and my son under the IBIT policy and consider my posting where facilities of treatment, education with required therapies for my son are available in the nearest service hospital. I have full faith in the organization to help me to bring the best out of the treatment of my child to overcome disability. Now, this is important. I will forever remain indebted to the organization for considering my and my husband posting in a station where the facilities for treatment education of my son are available at the nearest hospital. This, my lord, comes to be allowed at page 65. For my wife.
But the prayer was that we should be posted together with my son at a station where we can give him the treatment. On the next page, at page 66, Lordship will find my application is regretted. Application for posting on medical grounds of Major so
Where is the policy that you're referring to?
Yes, the policy Lordship will find at page 27. 26, I mean. 26, it starts, my son falls under 3B. Priority 2, P22. That priority, Lordship will find is given at page 28. How the officers are to be posted.
What
Clause
is
B.
priority P2?
Priority 2, my lord, I am at 3B2.
What does it say?
Those requiring parental family support, occasional specialist medical attention, and ASHA or special school facilities. I fall under that. Then Lordship will find the posting management at page 27. Just above para 10 is the posting management part. 10A, Lordship will have 10B on the next page. Officers having differently able dependents classified as P2 shall be posted to have requisite ASHA special school facilities and are in reasonable proximity to suitable specialist medical facilities. So the policy all the time speaks that the child has to have the parent has to be posted in a manner where the child can avail the benefits. Now here we are two parents serving in the same organization. The wife praying that me and my husband both be posted together for the ultimate development of the child was considered positively. If my request goes,
where is your wife? Where is your wife's
application?
Application.
What is that Lordship would find at page 61, and at page 62, para 9, second paragraph, last 3 lines if Lordship put it. Page 62, and both of us have given an undertaking that we understand that this will hamper our career prospects. Para 9, second paragraph, last 3 lines starts with the word my child to overcome disability. Lordship finds. I will forever remain indebted.
Where is that application first? This is the application.
This is the application of the wife, and the acceptance is at page 65. That you will be posted together. We accept it at page 65. That is on 7th of April 2025. They accept it. Application for posting of so and so Lieutenant Colonel Manisha.
No, what we want to see is,
my lord.
Your policy talks about an officer being a caregiver to a differently able child.
Yes.
To be posted in those places where you have those facilities.
True.
Here is a case where both the parents are
officers.
But the application is filed. I do not know from what I see, page 61.
Yes.
Is filed by an officer seeking posting in respect of
me and my husband.
Where do you find that?
Para 9
of
the second paragraph, page 62. My first Lordship will have my application first at page 54.
54.
This is the petitioner's application. The wife is not yet posted out. She is not under posting.
Right.
Para 10 at page 54, Lordship has. I request to register both the parents.
Where is that policy for registering?
Yes, that was a policy which I read out, my lord, at page 28.
What does it talk about registration?
Yes, Lordship will find at page 27. Para 4. An officer having a differently able dependent will forward his or her application as per formatted Appendix B through proper channel to the concerned controlling group in MS branch. The application will be duly supported by the medical documents and opinion of the medical specialist at Command or RR Hospital as per appendices so and so. On receipt of application from the officer, MS branch will seek comments from the DGS Army, which will scrutinize the case and forward its comments. In case of difference of opinion from the lower medical authority, decision opinion of so and so shall prevail. An advisory
But
board
it
will
talks
assemble
about
once in every
it talks about a caregiving parent.
Yes.
Does it talk about both the parents?
My lord, now lordship would kindly have this certificate at page 50.
Page?
50.
50.
And there are judgments with the effect, my lord, that the parents, at least the father, has to be constantly there. It does not give a right to the father, it gives a right to the child. But this, my lord, I shall read it. The child master so and so, this is issued by the Guwahati Medical College Hospital by the Associate Professor and Head of the Department, Dr. Maithili Hazarika. The child master so and so is seen by me for his disabilities and education. Testing indicate global developmental delay with autism spectrum disorder with 80% disability. He has ADHD features which is treated on medication. So and so incidental therapy for his delay in speech, social skill, personal intervention has to be continued. Parents are to focus on the child overall, so by something skill, by learning skills to deal with.
No, you show us something to say that both the parents must be posted together at one place in cases of
the thing is,
differently able child.
Now, there is nothing in the policy which says that both the parents will not be posted together. Now, in a case where a father is the only person giving the is in service, he is registered, he takes his family with him, the child, to a place of his posting. That is one. Now, when the wife and the when the mother and the father are both in the same organization, one child, both being posted differently will create chaos.
No. Both being posted differently will create chaos if you are posted at places where there is no medical or this kind of facility. But so far as the mother is concerned, she's been granted a posting where these facilities are available with the child.
So far as the mother,
she also claims to be the caregiver.
Mother's posting is yet to come up. Let us take a case, mother. In this autism case, the mother of the child has to attend to all her duties at all times. She's in the army.
It's not for the court to lay down a transfer policy.
That is what now this policy having been laid down by the army.
No. Question is you have to take into account the services that you're rendering.
True.
Right?
True. That is what this honorable court has also held.
Therefore, this policy has to be framed by the army headquarters or whatever policy the government of India has to frame.
Looking at everything, looking at all aspects.
Yes.
My lord, I'm sorry.
No, it's all right. So therefore, the important thing is whether the child is getting the care or not.
That has been laid down by not only this court but by other honorable courts, which is saying that the dependent at this age.
What is the age of the child?
3 years, my lord. And the certificates say that if not treated for the next 3 or 4 years properly, this disability will last a lifetime.
I can understand this argument if either of the parents are posted at a place where there is no treatment facility.
The issue remains here. Let us assume a situation where the mother is not in service. The father, when he takes the child with him to a place where the facilities are there.
That's a different issue.
Had
the father not
so therefore, my lord, what would happen is
had only one parent being an employed parent, then obviously that parent is the caregiver. So wherever the
caregiving does not come from the job of the.
Let us take that also into account.
Yes.
Because
now what
you need
happens?
some income to survive.
Yes.
So if a particular parent who's looking after the child
is taken away,
his
then income still comes. No requirement for him to carry the child with him. So that is not what the policy is trying to take care of. What the policy or the right of persons with disabilities act has been examined by this honorable court in different cases. I brought the judgment. Is that a disabled person has a right to the care of both the parents at the same time.
That's not for.
Well, that is what the
show us the judgment.
Yes, if lordship should have.
You show us the judgment.
I'll start with a reference to a Kerala High Court, then I'll come to the Guwahati High Court.
No, you show us Guwahati or Supreme Court.
Guwahati. I'll show
if you have Supreme Court, you show us.
Yes.
I know you're going to refer to Dhariwal.
No.
You're not.
I will not refer to Dhariwal in this case because what I was saying is not that it is binding.
I was thinking you'll refer to Dhariwal.
The logic which was followed by the High Court of Kerala is something which can.
That we'll examine on a later stage. we are today at the stage of whether we issue a notice or whether we grant you a stay.
No, that is what I was.
So
on
you
my
have to make out a case for stay.
My outdate is on 28th of
So you have
April.
to make out a case for
Yes.
stay that your presence here with the child is equally important.
Yes, Mother, I'll
That is applicable not only for army, it's applicable for all parents.
all of them.
By that analogy, no parent can ever be transferred out.
We are not against the transfer. The only thing is a consideration that both the parents go with the child to any place of their choice.
You show us that policy envisages that.
Yes, Mother, that is what 3 says. One parent cannot be left out of the policy. How can one parent be left out of the policy, Mother, just because both are serving? This is matter of 2020, where it was within the state itself. Lordships will have the last paragraph 5. Reliance is placed.
This is how the policy. This is the policy of the government of Assam. I think
This is a policy of the government, central government, my lord.
Okay.
6.4. Lordship will find reliance is based on the office memorandum of 6/6/20 for the government of India, where in paragraph 3 it is provided, considering that government employee has disabled child serves the main caregiver such as of such child. Any displacement of such government employee will have a bearing in the systemic rehabilitation of the disabled child, since the new environmental setup could prove to be a hindrance in the rehabilitation process of the child.
Let us hear, Mr. Chaudhary. What do you say?
Lordship, so far as my instruction is concerned, about the economic instruction, it says that with the vice that have the application, and that was based before the compassionate ground advisory board. Actually, it has stated that the child can be managed by one parent. Of course, I do not have the instruction, but otherwise, Lordship, normally, Lordship, the army, wherever they are posted, they will be posted in some area where there are lesser officers.
No, first tell us, is there a policy for posting both parents who are serving in the army in one place, in cases of they having a
The policy referred to by my learned friend in my upper certificate does not explicitly say.
Therefore, we are asking.
No, Lordship, if your Lordship will take up this matter day after tomorrow, so I'm expecting,
Day after tomorrow.
I'm expecting some instructions by Friday.
When are you required to transfer out?
28th, they have given a the last order says that I will have to carry out the order by 28th of April. That is on Monday.
Let it be on
And that
Friday.
letter was given to me on 19th.
Let this matter be posted on Friday, Lordship, I'll get the instruction.
You get it by tomorrow.
Tomorrow,
possible.
Lordship, may be difficult. Let it be day after tomorrow.
We'll have it on 28th.
28th, maybe.
In the morning, they'll strike me off the stand. So if it is 20th, then Lordship will say that on 28th, at least I'm not going out. Let it be on the 29th. Let my stacking off be on the 29th if they can. If it is on 29th.
All right, 24th.
Tomorrow, madam.
25th.
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 Yes.
As the first item.
Yes, sir.
List on 25th as the first item. Heard council so and so. Enabling the internal DSGI to complete his instruction. List on
25th.
Yes. It is 25th the first item.
Lordship, petitioner paying for compassionate payment, and DLC has rejected its prayer, Lordship.
The compassionate appointment now the
Lordship,
notification.
Lordship, WPC 342/2025.
Huh?
Lordship, we have not challenged the notification.
You have not challenged the notification.
Lordship, the matter has been filed, Lordship, before this,
No. There is a you show in that notification if you have.
18/9.
18/9, 2024 notification.
Lordship.
Are you aware of that notification?
Yes, Lordship, but this coordinate bench judgment, Lordship, that Lordship, it shall be last line, Lordship, it shall be applied cases pending before the court as on 3/4 before filing that Lordship.
Huh?
Before filing before 3/4/2025, Lordship. All cases, Lordship.
3/4. Your case is filed on?
Lordship, 28 March, Lordship.
But you did not challenge that notification.
All those cases, that notification was challenged. Specific order was issued with regards to
In your case, what happened? What was rejected?
Lordship for delay, Lordship. Page number.
Who rejected it?
DLC, Lordship. DLC rejected, Lordship.
See, in that matter, the challenge was made to that notification.
Lordship.
Therefore, the court said on consent order that don't apply the notification, reconsider their cases for all those matters which are filed on so and so date. In your case, that question will never arise because you have not even assailed the notification. And your case has been, see, most of these matters, they were rejected or they were directed to be placed for the SLC. It was not placed because of the notification. In your case, it's rejected by the
DLC,
on the ground of delay.
Delay,
It has to be examined independently.
Lordship, earlier, Lordship, my elder brother applied, Lordship. That has been not rejected, not accepted, Lordship. That has been not, Lordship. Case number, Lordship.
Not rejected by whom?
Lordship, not rejected, Lordship.
By whom? By which?
DLC, Lord.
DL. Lordship, rejected by the DL.
My case is not.
On the ground of delay.
Lordship.
Therefore, it has to be examined.
Lordship.
Has to be examined. Cannot be covered by the earlier judgment. And it is a rejection of 2023, and you have challenged it in 2025.
Lord.
Why?
Lordship, in last rejection, Lordship, in
Last rejection is 24.
Lordship.
11/9.
Lordship.
And when was the notification issued?
18/9.
18/9. So it was rejected. That it cannot be covered by the earlier order. It is for you to decide now. Please the matter again after 1 week, enabling the counsel for the petitioner to complete his instruction. Be Bora, government advocate, appears for it. You think and come back.
May please, your lordship. My lord, the petitioner is entitled for higher pension, but he has been paid lower pension, family pension. My lord, and the issue has been settled by the division bench judgment, Syed Mohammed Fazle Rafi, and as well as your lordship judgment. The impin order is, my lord, page 58 of my party.
Do you have a copy of the order?
Yes, your lordship.
Give us a copy. Yes.
Notice me to lordship. Notice me to lordship.
Notice. This is a covered matter.
But all the matters are covered, lordship. But after issuing notice, that matters were.
You examine it and come back and tell us on Friday. You examine this order, come back and tell us on Friday.
Friday.
List on 25th. Enabling the learned counsel for the respondent to apprise the court whether the matter can be disposed of in terms of orders passed in other similar matters as have been prayed for by the learned counsel. List on 25th.
Kindly oblige your lordship.
That is the lordship. In this matter, maybe my humble lordship is that one week can be allowed to file amendment petition, post title amendment, reflecting the name of respondent number 18.
You want to file amended post title?
Lordship.
Counsel for the petitioner prays for 1 week's time to file amended post title. List after 1 week, Mr. Yapuri appears for 4, 5, and 6. I mean, 10 day for respondent 1, 2, and 3.
We were not served with a copy of the writ petition. That may be
Copies of the amended course title be served on the counsel for the on the respondent by the counsel for the petition.
Much obliged.
definitely. As per office note, this is 9/4/25. It appears that due to mismatching of the respondent number 9, notice could not be issued by the registry. And so far, respondent 9 is concerned, earlier I filed one IA seeking correction of the address of the respondent number 9, and that IA was disposed of. But in the order of the IA, so just now I have seen the order of the IA, In the order of the IA, the respondent number 9 ought to have been, one Jamila Bibi, but it has shown as, Misron Bibi, Misron Bibi is the respondent number 10, Earlier, the address of the respondent number 9 was, address was, Raipur, POPS, Gologonj, district, Dhubri. Now, the correction should be made, at the address of her husband, this is husband, that is, Tokemari, Sadil, Part 2, Binna Khata, PS, Kuchaiko, district, Koraja, This is the correct address, And my IA was also allowed, But in the order, respondent number 9, name of the respondent 9, Jamila Bibi, ought to have been there, but instead of Jamila Bibi, Misron Bibi is mentioned, and ultimately registry could not issue the notice. This is itu buat. Kontak nomor kami review itu kami review itu notice. Cek dulu.
One consent is also pending by the Jamila Bibi. Okay. Really. See what? It's like it was.
3 wives. Jamila Bibi was the first wife. She left the husband's house. Then petitioner is the second wife. One more wife is there. That is Misron Bibi. Out of the
What is the address of Jamila Bibi?
Now the the address, the correct address is Kushaigao, Earlier it was shown as
Give us the complete address.
Earlier address was given at Gologonj. It is our parents' house, parents'
What
address.
is the correct address of your,
Jamila Bibi.
yes, Jamila Bibi?
My lord, now the correct address is, my lord, village Tokiyamari, Shadbil Patu, Post Office Binakata, PS Gusaigaon, District Kokorazar, BTR Assam.
And what have you stated in the IA?
In the IA itself, my lord, this address has been the.
Do you have a copy of the IA?
Yes, my lord.
Come to page number 5.
Page number 5. Yes, my lord. This is the earlier address. But the address should be corrected, my lord. That address has been shown is page number 6, para 2, my lord. The bottom last 3 line.
You have to file an application
For correction.
because this IA is disposed of. File an application.
Otherwise, my lord, at the same time, my lord, my learned friend also, my lord, stated that one contempt has been filed because the earlier one, this Jamila Bibi, earlier filed one writ petition, my lord, without implementing the present petition and the other wife. That writ petition was disposed of at the motion stage, directing the authorities to consider the representation. Now, later on, after filing this writ petition, I came to know that one writ petition earlier was filed by the first wife. Now, against that order, since I was not implemented as a respondent, my lord, I filed one leave application. Leave application was allowed, and the review application was filed. In the review application also, notice has been issued to the earlier the Jamila Bibi. Now the Jamila Bibi filed one contempt petition also. So for my learned friend has said. So this matter also maybe, my lord, tag with the.
But you have corrected first.
My lord.
For correction, you have filed an IA.
I'll file IA for correction of the address, my lord. Please, my lord.
You file an IA first. Counsel for petitioner seeks liberty to file an IA for seeking correction of the address of respondent number 9.
9.
Prayer made is allowed. It's after 2 weeks. Ms. R.B. Bora appears for the Boroland Territorial Council. Mr. P. Sharma for AG. Mr. Your name, please. M. Rana appears for respondent number 10. MS so for respondent 1. MS U. Sharma for 2, 6, and 7. Yeah.
All right.
This may have a look at the last order asked in the IA. They were required to file their affidavit, and there was an undertaking that they would give us an extension if the election took. Now, no extension has come, no affidavit has come.
Who is the counsel for?
Mr. P. Chakraborty.
B. Chaudhary.
B. Chaudhary.
Where is Mr. B. Chaudhary?
Otherwise, this delays finishing of my extension.
We'll take it up in the second half. You inform Mr. B. Chaudhary. Oh, he come. Here he comes.
Lordship, we are finding the affidavit during the course of the day. Lordship may take it about either on Tuesday or Wednesday, Lordship.
Yes.
My Lord, Lordship should find that our extension was ending, and therefore there was they would give it up to May. My extension ends in April when Lordship passes this order in March.
When are their extensions ending?
Their extensions has come, we are
They
hanging.
have prepared it and it will be issued within a day or two, Lordship.
What will be issued?
The next extension order.
Next extension.
Yeah.
Right, then this is you are filing an affidavit in the IA or in the main case?
In the main case, Lordship, covering every aspect.
All right.
Lordship.
Mr. R. Mazumdar for the writ petitioner and the applicant in the IA. Mr. P. Chaudhary appearing for the Agricultural Department. Agriculture Department submits that the affidavit on behalf of the department will be filed during the course of the day. He further submits that the next extension in respect of the writ petitioner is being prepared, likely to be issued within a few days. So, Mr. T.J. Monto appears for APSC. And, Ms. Wensu appears on behalf of R.K. Talukder, Accountant General. So, since the affidavit since it is submitted, the affidavit will be filed in the course of the day with the matter being again.
Lordship on 30th.
On 30th. On 30th. On 30th.
I understand that the people will not be. No, it will not be done because the APSC advertisement last date it was only on 19th. Okay. It will take some time.
30th.
Knowledge.
In this case, my lord, they have filed one IA. Now I want to file objective. So 2 weeks time.
IA for?
IA
is for?
as modification and alternation of
Okay, heard
interim
in
order
the IA.
24/4
Heard Senate Council for the parties issue notice returnable 4 weeks. Of the parties are at liberty to file their objection / affidavit if to advise the list after 4 weeks.
The interim order matter.
Interim order passed earlier will continue.
Due to pendency of the interim order.
3 weeks, returnable 3 weeks.
Hello. This is an IML for substitution of the deceased petitioner by his wife.
Any objection?
No, sir.
Heard counsel for parties, this application is been filed by the petitioner seeking substitution of the legal heirs of the writ petitioner who expired during the pendency of the writ petition. Topic is submitted that the right to sue survived as the what was claimed by the petitioner?
What the old pension scheme.
As the claim of the deceased petitioner was in respect of its claim arising out of claims relating to pension. So, respondents are represented by Departmental, Mr. But your report, Accountant General, and MS U Sharma for the government. Any objection? See, he's so magnanimous. Even after not serving a copy, he's not objecting. The respondents do not object to the prayer made accordingly. The I is still allowed. Petitioner is the applicant be substituted. You are the only legal heir.
Look, I have other sons and daughters.
Then
being wife, I'm the wife.
No, they will also have to be brought in. Are they minors?
Not minors.
The applicant, free so and so, and the other legal heirs, as reflected in the next of kin certificate dated 1/4/2024. Within bracket annexure B to the IA. We substituted as the legal heir of death Chanakya Supradan. So, the IA accordingly stands allowed. Applicant will file amended court title before the registry within 2 weeks. Yeah. I report in WPC number 22, UOP, order passed in the I. So and so are substituted as the legal heirs of late so and so. Petitioner will file amended forthright within before the registry within a period of 2 weeks.
All right.
Hmm? You take a copy from the council. Our corpusary appears for opposite party. But yeah.
All right.
Hey, please. In this matter, challenge the termination order. In earlier,
Within 7 days, they are going to furnish the relevant comment. Can you please after 10 days? I will file my
Notice issued.
Lordship in 26/10/2022, Lordship 4 weeks granted, Lordship 17/7/23, 4 years, Lordship affidavit not filed.
I will tell you.
4 years.
Mr. Your name?
AU Ahmed.
Mr. A.U. Ahmed appears for the petitioner. Mr. B. Gugoi, petitioner maybe appears for all the respondents. Mr. Gugoi submits that the affidavit on behalf of the respondent will be filed during the course of the day.
No,
I'm sorry,
10 days.
within 10 days.
Yes, to receive the instruction, not going to try to 40%.
Praise for 2 weeks and praise for further 2 weeks time to file his affidavit. Prayer allowed weeks after.
Maybe to last transfer. Because the 4 years.
It is made clear that the if the affidavit is not filed as permitted, the court may proceed to pass orders on the basis of the pleadings available on record.
Okay.
Your Lordship.
Yes.
The payment has already been made.
Matter has become infructuous. Do you have any documents to show?
Yes, Lordship. The sanction order. The petitioner's name is at serial number 35 and 38. Item number 28 is 38, serial number
All the
30.
payments received. All the payments.
Yes.
Right. The present writ petitioners have filed this writ petition. Seeking a direction to the respondents to release the salary and arrears salary, along with gratuity, leave encashment, and other retirement benefits, which the petitioners claim to be entitled to, as they had superannuated from their service from the Assam Plains Drive Development Corporation. So, petitioner in WPC 4360 superannuated on 31/3/2020, and petitioner in the other petition WPC 6760 of 2022 superannuated on 31/5/2011. 2011. during the pendency of the proceeding, the corporation took steps for towards release of the amount due the petitioner along with other similarly situated persons. Learned counsel for the respondent corporation has placed before the court the sanction order dated 3/11/2023, by which the various amounts have been sanctioned in respect of the employee, including the present writ petitioner. The first writ petitioner is at 38.
Yes, sir.
The first writ petitioner's name appears at serial number 38, whereas the second writ petitioner's name appears at serial number 35. Right? WPC, petitioner in WPC appears in a further communication dated 3/11/2023 is also placed before the court, which shows the amount being credited to the respective accounts of the persons concerned, including the present writ petition. With that view of the matter, it is clear that the grievances raised by the petitioner have already been redressed, and there is no further cause to pursue the writ petition. Accordingly, although none represents the writ petitioners of the matters being called, since the grievances have already been redressed, and there is no further cause for the petitioners to pursue before the court in the present proceeding, the present writ petition stands closed without any further direction. Imprimotors, if any, stand vacated, pending IS are also disposed of, dismissed. The copies of the communication placed to the court are kept in the case report. Mr. R. Thorpor, 1 and 3, Mr. R. Borbuza report. Respondent, fine.
In this matter, I have received the instruction matter. I want 2 weeks time to file my affidavit.
Mr. U. Dr. for the petitioner, Mr. H. Dr. for the respondent, who submits the instructions have been received and you'd like to bring it on record by way of an affidavit. He prays for 3 weeks time. Please, after 3 weeks.
Hello.
Mr. D. Bora for respondent number 4.
Hello.
Please, Lord. Lordship, matter is to compensation department lordship, and it is a second note of litigation lordship. The earlier case of the petitioner was considered and recommended by the DLC, and the same was not placed before the SLC. Subsequently, the petitioner approached this honorable court, and this honorable court has directed the responsibilities to place the petitioner in the next available SLC, but the same has not been placed. Thereafter, some communications were there. Thereafter, the petitioner in the year 2023 has again approached this honorable court with a limited prayer to place his case before the SLC and to consider in accordance with law. That is the limited prayer. Possible find
Who for the respondent? Mr. Dhor? This is Tima Hasao. Who is to place it before the which SLC? Which is to be placed by which respondent?
No, my lord. Usually, my lord, DLC forward this to the district level committee.
But in view of the notification, perhaps it
Yes,
may
my
not
lord.
have been done.
It may not be placed. So unless the challenges that OM, my lord.
So we'll dispose it of in terms of the earlier order. Why the OM is to be challenged? Because there's no discussion on merit. This is with regard to all writ petitions filed before as on report. This was filed before that. You consider it, place it, and it was not placed before SLC.
No.
So let me place and we will consider it termed in tune with para 7, 8, 9 of that order. What else? Anything more you want to submit, you tell us.
No, my lord.
Challenge to the notification is irrelevant because no discussion on merit in respect of that notification.
That's not OM stands, my lord. Since that
That's right, the OM stands, but
OM
notwithstanding that, there is a cutoff date prior to which the writ petitions are to be considered.
writ petition filed challenging the OM. That is what the paragraph says, my lord. That, my lord, in para 9, my lord, it is specifically stated that prior to those writ petitions filed challenging the OM prior to the date.
What difference does it make effective?
Suppose, my lord, effectively, the difference will now, my lord, come. Once my lord sends it back to the SLC, SLC will take.
No, we say that in view of the, although the OM is not challenged, in view of the orders passed, those matters, this matter be also considered in the same light.
My lord, then there will be contradiction, my lord.
Why?
Because the order in the, my lord, series writ, my lord, there is specific that.
That's right. We'll extend the benefit to these matters also.
My lord, that cannot be, my lord.
Why?
Because that order cannot be treated as precedent where the OM is not under challenge.
We are not treating it as the precedent. We are saying that the benefit will be granted in that is also to be applied here.
Cannot be, my lord.
Why?
Because in those writs, my lord, the OM was under challenge. And the specific direction is that, my lord.
No, that is what we are asking you repeatedly. The OM was under challenge, but there was no finding on whether the OM is correct or incorrect. You can't say that after discussion on merit, the court upheld the OM.
So OM stands, my lord. So since the OM stands, my lord,
right.
Now if the OM is not challenged in a writ, my lord, that will my lord, come in between.
This whole confusion has arisen because of whatever has happened.
Yes, my lord.
Now, in those matters, the OM stands. Yet the court directs them to consider it without reference to the OM.
Only because those in those writs, my lord, OM was under challenge.
It is not so technical. How does it affect the decision of the court or the department
My lord,
where the OM is not challenged?
My lord, the OM is very specific. OM says that in the last paragraph that in view of the Tiwari, the state is taking a decision that no further, my lord.
Right, but the court has directed to the consent order.
Consent order only specific only on those writs, my lord. Those are under challenge. My lord, because my lord, why I am arguing, my lord? Because tomorrow more writs will come and there will be more confusion, my lord.
To come. You are giving giving a benefit to somebody who has put a challenge to the.
Yes, my lord. That is why, my lord.
The direction, if I remember, if I recollect correctly, the direction of the court is not the authority to consider whether their cases will be covered by the OM or not. The direction is that up to 2017, whatever judgment, whatever notifications you consider their cases past order, and also in the light of electoral divide.
And only in those writs, my lord, where the OM is under challenge.
You are repeatedly asking. We are trying to understand.
That is the crux, my lord. That is the order, my lord.
No, we are asking. I know that is the order. That benefit of the order can be extended by this court. An order passed by this court.
My lord.
What we are asking you, how does it create a distinction between these matters being not challenging the OM. and
Pause,
those
my,
matters,
pause, my lord, OM is, my lord, as of today, is in force.
we are not saying the OM is not in force.
Pause, my lord, the moment, my lord, it is sent, my lord, the OM will come in between because government has taken a decision.
That you have already agreed to do.
My lord, only for those cases where the OM is under challenge.
Correct. But you have still agreed to consider the cases without referring to the OM which is passed by. This OM is issued by the government.
Yes, my lord.
OM is challenged before the court.
Exactly, my lord.
You agree that we will consider the cases without reference to the OM.
Only those cases where the OM is under challenge.
Exactly. But how does it distinguish the cases of those petitioners and this petitioner? You are only required to consider it on the same line. You cannot refer to the OM in view of that order.
Yes, my lord.
So don't refer to the OM in these matters also. Consider it.
Pause, my lord.
You have agreed to consider cases without referring to an OM.
Only limited to those cases only, my lord. That is why, my lord, it will not be treated as a precedent, my lord. That line was added, my lord. That is the problem, my lord.
That, but you must give a appreciable reason as to how it is going to affect.
Because, my lord, once we go for consideration, my lord, where, my lord, the OM was never challenged in a read.
No. See,
that will come into effect, my lord.
You are the government. You cannot say that those writ petitions they are fighting, they are challenging, will consider those cases rest in order. Because ultimately it is your stand that there is an OM. In terms of this OM, no further consideration. That OM has not been interfered by the.
No.
Yet you proceed to consider this without reference to the at your own possession. Even if we say that the order of the court not a precedent, you have to explain your conduct. So why the government's action of giving benefit to some writ petitioners are deprived from the other writ petitioners.
My lord, we only consider that only to that limit that where the OM is under challenge, only in those reads. And the rest, my lord,
I have read it.
And the rest, my lord,
what we are asking you,
my lord,
what we are asking you, how does it affect? How does it change the? How does it change the circumstance?
And the rest, my lord, I think my lord will do address, my lord will dispose the matter on merit, my lord, activity on merit, on the my lord. Now, it will be little, my lord, different, my lord. It is on merit, my lord.
Yes.
Yes, Lordship. For if Lordship, when the representation files Lordship, the OM is not in.
Have you seen the OM? You have read the OM. The OM, you have to tell us why the OM shall not be taken into account.
Because Lordship,
you have not challenged the OM.
Lordship, when this representation has been filed, Lordship, it is of 2020 and OM has came into force on 18/9/2024, Lordship. And during pendency of the instant writ petition, Lordship, the OM has come in force. And in that, during the course of hearing, Lordship, the respondent took time to file.
No, because see, there is no point in giving a finding that since so and so date the OM has come into force, therefore all other cases prior to the OM will be considered. The government has taken a decision that in view of the attending circumstances, we have issued this OM, no further consideration of population required. If you are aggrieved, you have to put it to challenge.
In that Lordship, then Lordship, I will be allowed to file an IL.
You file your I. But Mr. Dhor, please think about it.
My lord, I know, my lord, I'm going to think such questions every day, my lord, from Lordship, because that order, my lord, yes, put.
You are considering cases. Divorce the OM.
Yes, my lord. Now, my lord, That is what my lord, I'm trying to impress upon my lord, your lordship, that now these cases has to be dealt on merit, and my lord will has to pass an order on law, my lord, as of today.
All right, we'll see. You file your IA. Counsel for the petitioner prays for filing an IA to bring on a record to challenge the OM dated so and so. What is that date?
18/9/2024.
18/9/2024, which has been issued by the government. So, Mr. R. Ford, an additional government advocate, appeal for the respondent. MS Yen, respondent 5, 6, and 7. List again after 2 weeks.
Obliged.
May I please come? My lord, here the petitioners, my lord, they are the casual workers, working, my lord, as peon, tax collector, etc. And their names have been, my lord, sent forwarded by the concerned.
Yes, any instructions?
My lord, although my lord, from the commissioner, district was asked to produce some records, my lord, that was not received yet, my lord. Some further time is required, my lord.
You are working as what?
My lord, petitioner number 1 as peon, petitioner number 2 as junior assistant, 3 again peon, and 4 at tax collector.
In where are you working?
Now, my lord, we are working. Now, after delimitation, all are working under Nagaon. But petition number 2 earlier was working under in the my lord, block development office under Morigaon. But now, after delimitation, all are working under Nagaon. My lord, their names, my lord, after verification have been, my lord, forwarded from page 47 to 52. Their names have been forwarded.
Forwarded to whom?
Forwarded to, my lord, commissioner and secretary, my lord, by the concerned chief executive officer. Kindly see page 47 to 52.
Yes. And what orders have been passed here, Mr. Dotto?
My lord, as per page 48, petitioner's number 1's name is serial number 12, my lord. And this page is showing that she is post FRBM.
As per working certificate, my lord.
48, page 48. 5 row from top, my lord.
So what happens if it is post FRBM?
Post FRBM, that then they are not regularized is not for them. Only fixed pay.
So you're not receiving your fixed pay.
No, man.
For that, my lord, I need some instruction.
Who is to release the amount?
My lord, here, my lord, similarly situated persons have order has been passed by, my lord, commissioner of Panchayat, my lord.
Where is that?
This order is, my lord, 58. 58 to 59, my lord. Commissioner has passed this order.
These are engaged prior to FRBM.
Yes.
Prior to.
So here, in my case also, my lord, all petitioners, they were, my lord, engaged prior to, my lord, 1st September 2005. But one name while sending in that, my lord, forwarding letter, my lord, it may be mistakenly written, my lord. But in the working certificate, and it is shown, my lord, prior to, my lord, 2005, my lord. In the working certificate. Kindly see here, my lord, working certificate from page 21 to 24. Page 21, my lord. In respect of petition number 1, my lord. Putuli Divi, my lord. She is working, my lord, since her date of joining, that is 18/8/2005, my lord.
No, but these are all pre-FRBM. Page 58.
My lord.
These are all pre-FRBM. In your case, who's pre-FRBM?
My lord, here, my lord, petition number 224, 2, 3, and 4.
Where are their names? In the chart?
My lord, page 47 to chart, my lord, in the body, my lord. Body, my lord, page 9, my lord. Of my
No, in the chart, page 48, 47, 48. Where are their names?
My lord. '47 and 48, my lord. Petition number 1, my lord, at Putuli Devi, my lord. It is 12, my lord. Serial number, it will be 12.
12.
12, my lord.
Petitioner 1.
Petitioner 1, my lord.
He is post-FRBM.
Here, my lord, 15 to 2008 date is given here. But in the working certificate, that is, my lord,
his own
post
documents are
FRBM.
contradictory.
No, but these are post-FRBM.
And now, my lord, petition number 2, my lord. Kindly see page 50.
So you are saying that names have been sent, verified and sent.
Yes, my lord.
In the chart.
Yes.
You show us the names in the chart.
47 to 52, my lord.
Uh,
This is one petition number 1, my lord, page 48.
Then?
And then, my lord, 50.
50.
Page 50. Petition number 2, my lord.
Petitioner 2.
Midul Malakar, my lord.
Then?
Then, my lord, petition page number, my lord, 52. Petition number 3, my lord, and petition number 4. This is typed, my lord.
So these are all post-FRBM.
13 date of engagement 13/6/2003, my lord, and 21/3/2005.
May I suggest one thing, my lord? My lord, these certificates and all the letters, my lord, are from district level, my lord. Lordship may direct the commissionerate level, my lord, to conduct an inquiry, my lord. After inquiry, my lord, that inquiry team will submit the report to the lordship, my lord. Because thereafter, my lord, the sanctioning authority is the finance department only, my lord. We can only forward to the finance department, my lord. So if inquiry will be conducted, my lord, then only lordship may.
Why don't you bring the department and place it before the registry? We'll handle it.
That can be
You
also done, my lord.
want one direction to the department to conduct an inquiry,
My lord,
another direction to send it to
My
so
lord,
and so department.
I'm saying about my department only, PNRD department, my lord.
Your department is a part of the government.
Yes, my lordship's
We
order
see
will help
government.
me,
We
my lord,
see
to
government
conduct.
as one whole organization.
My lord, lordship
You
is
may have your department for effectively carrying out the work.
Lordship is very much aware that now Panchayat election is about to.
Panchayat election is okay, but what have you been doing prior to that?
That already is going on, my lord. After the filing of the requisition, my lord, that part is already going on, my lord.
You are
The
not
district-
filing your affidavits.
Yes, my
You are
lord.
not
After
bringing your instructions.
receiving of the report from the districts, my lord, we are going to file the affidavit, my lord.
Similar order also passed, my
Sometime
lord.
maybe.
Page 54 to, my lord. Page,
it's an every case is different, my lord.
Page
Similar order
57,
will
my
not
lord.
work, may not work, my lord.
In this line, similar order can be passed, my lord.
Page
After-
number?
Page number, my lord, 54 to 57. And my lord, 56 is the starting date.
These are all pre-FRBM.
No, my lord, I'm my lord.
54 to
54, my lord, similar order. I'm my lord.
54.
54 page. 54 to 57, and it starts from, my lord, 56, relevant portion. A similar order was passed by this honorable.
There is no finding on merit.
Yes. Well,
There is no finding on merit.
not on merit.
Then
For verification.
if you have no case, we'll dismiss it. Why should we pass a similar order without anything on merit?
Okay, my lord. It may be passed on merit after the, my lord, the, affidavit.
You satisfy the court that you are entitled to an order from the court. We are not passing similar orders just like that.
Here, my lord.
What is your claim?
Page 21 to 24, my lord, this is my lord working certificate.
Hmm.
And then, my lord, page 47 to 52, my lord, our names have been forwarded by the concerned chief executive officer, my lord. Page 21 to 24, my lord, working certificate.
(21 to
21 to 24. These are, my lord, working certificates. And still we are working, my lord.
Why are you working without salary?
They are
How
getting,
many
my lord,
months you are not getting your salary?
they are getting salary, my lord, but as per their own part.
That is that.
Because from 2005 without salary, how can they work, my lord?
You want the benefit of fixed wages.
Fixed wages.
Huh.
For fixed wages, my lord, our names have been forwarded.
Benefit of open das case.
Upendra.
Who is to give you that? Who is required to pass? Who is required to undertake that exercise?
Sanctioning the appropriate authority is the finance department, but before that, my lord, we have to verify on record by the records, my lord, whether these are correct or not. After verification of records only, we can forward their names to the finance department. Without verifying the proper records, my lord, we cannot, only basis of certificates, my lord, we cannot forward, my lord. That stage is going on, my lord. Whether they are originally they are from before the cutoff date or not. Because in numbers of cases, my lord, they have annexed the forwarded their names, my lord. But
Who has forwarded your name?
Chief executive officer.
Where is that?
My lord, paragraph
page 47 to page 52.
Who is the chief executive officer? Is he a government officer?
Yes, my lord.
Huh?
Yes.
So has he forwarded these names without verification?
My lord, that has to be supported by the records, my lord. Sometimes what happened, my lord, names were forwarded, but not supported by records, my lord. Those were rejected, my lord, later on, my lord. And as per this forwarding, my lord, petition number one is showing post FRBM, not pre FRBM. Now in the repetition, she is claiming that she is pre FRBM.
You tell us from this Upendas, is there a criteria of post and pre FRBM to be looked into? Where is that? Which paragraph?
My lord, page 40, my lord. Page 40, my lord, of my writ petition. Paragraph 22, my lord.
Page 40. Yes.
We are asking you something, you are giving some other response. We are asking you whether in Upendas, is there a direction that only the benefits shall be extended only to those pre-FRBM worker.
No, my lord. For post FRBM, my lord, fixed wages, my lord. After this judgment, my lord, Finance Department had issued one office memorandum, my lord.
Where is that?
Memorandum, I think they have not annexed.
53.
Yes, Annex 10.
No. Let us come to 53. Under 53, you are giving this benefit to post pre-FRBM.
Prior to FRBM. Yes.
Prior to. For which they will have to be appointed prior to FRBM. And subsequent to this, what notification has come?
My lord, even if we go by records, my lord, at page 47 to 52, petition number 224, my lord, they are engaged prior to FRBM period, my lord, 1st September 2005. Three petitioners engagement, my lord, prior to 1st September 2005. Now only one, my lord, that is, my lord, whether it is mistakenly or, my lord, what, I am not also clear. But so far, the, my lord, working certificate concern prior to, my lord, FRBM. She also comes under this, my lord.
I heard. Heard counsel for the party. Petitioners before this court are employed in various. You are working in Gaon Panchayat.
My lord, my Gaon Panchayat office and then, my lord, block development
Gaon
office also.
Panchayat and block development. The particulars are specified in para 3 of the writ petition, page 9. The petitioners 1, 2, 3, 4 are shown to be working in the following places as under expected chart. The petitioners claim that in spite of rendering services without any blame or blemish, they have not been given the benefit of monthly fixed pay, fixed wages, as have been done in cases of other similarly situated persons. So, counsel for the petitioner has read judgment of this court rendered in Pendas. In this matter, the division bench had recorded the submission of the state that in this judgment, this court ultimately decided that the state government shall pay the minimum of the pay scale to the master role workers, work charge workers, and similarly placed employees working for the last 10 years within bracket not in sanctioned post with effect from 1/8/2017. This order was passed in the light of the judgment of the apex court rendered in Jagjit Singh, reported in 2017, 1/148. So it is submitted that pursuant to the said direction, the cases of the petitioners were also considered, were examined and forwarded to the Commissioner, Panchayat and Rural Development, namely responsible pursuant to by the Chief Executive Officer, Nagaon Dila Morigod,
Nagaon and Morigao.
Nagaon and Morigao Dila Morigod, whereby the names of the petitioner were duly forwarded with all relevant particulars. So, the in so far as the petitioner number 1 is concerned, the communication was forwarded on 3001/2019. In so far as petitioner number 2 is concerned, the commissioner, the communication was forwarded on 1/10/2020. And in respect of petitioner 3 and 4, by communication dated 8/2/2020. So, however, this, in spite of all this information being furnished, no steps have been taken by the respondent authority to pass necessary order in respect of the petitioner. So, it is submitted that the Finance Department by notification dated 8th of March 2019 has also issued the necessary notification pursuant to the orders passed by this court in Writ Appeal 45 in Upendas. Although notices in the matter was issued as per package 23/6/2023 and opportunities were granted to the respondents to complete their inspection by necessary affidavit. No such affidavit has been filed in spite of time being granted, opportunities being granted to the respondents on subsequent days. So, today also when the matter is called up for the respondent, the PNRD department seeks further time to complete the inspection. So, the counsel for the finance department, the other hand, submits that the cases of the petitioners are to be examined by the administrative department, namely the Panchayat and Rural Development Department, and thereafter, upon the relevant material, relevant particulars being furnished through proper channel to the finance department, the necessary orders thereon as called for, passed by the finance department, considering the claims raised by the petitioners and duly submitted by the administrative department. So, having given due consideration, submission made at the meetings available before the court, this court finds that this court is constrained to hold that the Panchayat and Rural Development Department has not been able to apprise the court as to the status of the particular status of the claims of the petitioner for payment of fixed pay wages fixed wages. So the Council for the Panchayat and Rural Development is also not posted with specific instructions as to the stage at which the cases of the petitioner are presently placed before the department. Under such circumstances, the court under such circumstances, the court is constrained to direct the respondents, more particularly respondents 1 and 2, to take all steps necessary to cause the any verification or inquiry into the claim made by the council, made by the petitioner towards the claim for payment of fixed wages in terms of the directions issued by the this court in Vendas Supra. So the department will ensure that the inquiry, if required, if necessary, be undertaken by the concerned departmental authority in respect of the claim for petitioner within a specific time frame. Thereafter, submit all necessary particulars duly supported by the relevant papers and files through proper channels to the finance department for consideration of the claims of the petitioners for payment of fixed fee in terms of the direct related number. Read 45 of 45 Upenda Supra. So the counsel for the petitioner has apprised the court that the panchayat elections are presently underway and the same is likely to be over on 15 May. Yeah. So accordingly, this court disposes of the writ petition, directing the respondents 1 and 2 to complete the necessary inquiry and investigation if required, and place all particulars pertaining to the petitioners before the finance department within a period of 60 days, 3 months, 90 days from the date of receipt of the certified copy of this order. So the finance department, upon receipt of such particulars from the Panchayat and Rural Development Department, will pass necessary orders within a further period of 60 days therefrom. Writ petition accordingly disposed of. Yes.
Lord, we have been imputed wrongly.
Huh?
Lord, we are Silchar Municipal Board, but then these two petitioners, they're working in the water supply scheme at Hailakandi and one at Lala. So therefore, those two organizations ought to have been imputed the part.
You are representing
Silchar Municipal Board, respondent number 7.
Silchar Municipal Board.
Right.
Yes.
My lord. Let them file their affidavit, my lord, because they
You can file an application if you
Yes.
want. Better to file an application.
Yes, sir.
Mr. AMHR.
AHMR.
AHMR Chaudhary. Appears for the petitioner, Mr. S. Dr. London City Council, assisted by LSS, elected for respondent number 7. Stop. Mr. Dr. submits that respondent 7 has been wrongly added as the party respondent. It's not a necessary and a proper party in the present proceeding. The claim of the petitioner is submitted that the claim of the petitioner before this court is for what?
For because the water scheme supply scheme is there, the sewerage body has there is a proposal by the government to hand over the scheme.
No, you are in respect of their salaries.
Yes, salaries. Yes,
Salaries. In pursuance to the salaries for services rendered as master role workers under different water supply schemes run by the Assam Urban Water Supply and Sewerage Board, Barak Valley Division. Stop. Subsequently, this water supply board handed over the projects to the Silchar Water Supply Scheme to the Silchar Municipal Board.
So to the respective, the concerned ULBs, urban local board.
Not to the Silchar Municipal Board.
No.
Huh?
If you look at, that page,
all right, to the
page 29.
To the respective urban local bodies, and they are responsible for payment of salary to the petitioner, and therefore the respondent number 7 is not a proper party. Well, considering the prayer made by the learned senior counsel, he is accorded permission to file necessary application seeking the name of respondent number 7 to be struck off as prayed for. Please accordingly after 2 weeks.
Yes, my lord, other respondents may be directed to file their affidavit, my lord, because
Yes, other respondents. Counsels appearing for the other respondent are permitted to file their necessary affidavit in the meantime. List again after 2 weeks.
Lord, a date may be
We'll see about that. Yes.
my lord, a date may be fixed because my for last 2
He
years
has to file an application within 2 weeks. You will file it within 2 weeks.
Yes. In this case, last occasion, the government was directed to take instruction, my lord, why the interview was not, after cancellation, the interview was not held.
Now it will be held, Your Lordship, as per the latest instruction dated 10th April.
Can you show it to him?
Yes.
My lord, my instruction is that only with respect to this center, no this interview, nothing, no advertisement. With respect to other center, it was conducted. But so far is with respect to this applicants is concerned, there are no interview, no press initiation of press selection was held.
After election. After election. FTC. This will happen after the election, immediately after the election. Now, due to the MCC, the interview cannot be, that advertisement cannot be quoted.
You are saying that for this center, no advertisement is issued.
Not yet, because of the MCC, the Model Code of Conduct, due to the Panchayat election. After in the instruction is the last line. Immediately after election, fresh election process will be conducted. The matter may be closed here.
So selection process will be conducted pursuant to an advertisement.
Advertisement.
Whether
Advertisement.
an advertisement has been issued or not.
No, advertisement has
Your
not been
instructions
issued.
doesn't say so.
But I have been told telephonically that.
You will record your submission.
Yes, Your Lordship.
Third Learned Counsel, Mr. D. Bora, Learned Government Advocate, Government Advocate, has submitted to the court that the selection process of the Anganwadi centers will commence after the ensuing Panchayat election as model code of conduct presently. He also submits that insofar as the center in which the present petitioner is working, namely, what is the name of the center?
No, we are not working, my lord.
Huh?
No.
Pursuant to advertisement, we have applied.
No, the center in which the petitioner
Under the local Lanka ICDS project.
Namely the Lanka ICDS project, no advertisement has been issued. He, however, submits that the advertisement will be issued after the completion of the ensuing Panchayat. So, I submitted the matter
After 4 weeks.
on 30 May. 30 May, by which time the respondent will apply for the process undertaken for selection and appointment. So and so that body it's on 30 May.
May it please, Your Lordship. This is a matter, my lord, wherein the petitions, my lord, they have been deprived of the promotional increment benefits, my lord. And in the meantime, my lord, the petitioners, they have all retired, and they have been deprived of the benefits of increment which they are entitled to under the RP 2010. This honorable court was pleased to issue notice last year in the month of August. Till date, they have chosen not to.
Your Lordship, we have received the Paravas comments. Your Lordship, we would like to file an affidavit. Otherwise, we have, in terms of the Paravas comments, we have recommended the case of the petitioners to the AG. Now, the AG has to take a call as to whether or not they are entitled or not.
My lord, for this,
If Your Lordship perusses to just one.
AG has to, it is for you to take the call.
We have taken the call, Your Lordship. If Your Lordship peruses just to one particular paragraph of this instruction.
No, we don't want to see your instructions. If you want to bring it on record, bring it on record.
We will bring it on record.
my lord, in the meantime, if I may just point out, my lord, paragraph 64, because I have my doubt whether proper instructions has come to my learned friend. Page 64, sorry, page 64, annexure 11. This is a letter from the department which my friend is representing, dated 16th of August 2021. My lord, may kindly bear with me. I would like to place this, my lord. With reference, this is a letter to the AG. With reference to the subject cited above, I am directed to inform you that this department has consulted the matters of fixation of pay in respect of promotion from Inspector of Police rank, APS junior grade with Finance PRU department, as the matter is related to rules of ROP 2010. Finance department has accordingly conveyed their views in consultation with Finance Establishment Department, which is reproduced below. Now, Finance Department observes that as per Rule 23 of the Assam Police Service Rules 1966, the initial pay of a member of the service recruited under Rule such and such should be fixed in the junior grade time scale at the stage which corresponds to, or if no stage corresponds at the time scale next above, the amount arrived at by addition of rupees 60 to the pay last done by him in the rank of Inspector of Police. However, this is important, my lord. As per provision under Rule 11 of ROP 2010, pay on promotion on or after 1st January 2006 is to be fixed as follows. Straightaway fixation of pay from the date of promotion. My lord, I will skip the serial number 2, my lord. 1 increment at rate 3% of 1 above. My lord, this is what I am entitled to. Now, if I skip, my lord, and I come to the next page, my lord. After that 8, my lord, it is seen that Rule 23 of the Assam Service Police Rule 1966 is not in accordance with the Rule 11 of the ROP Rules 2010. Whom a department is requested to examine the case keeping in view Rule 15 of Assam ROP Rules 2010 and take necessary decision on the matter at their end accordingly. Further, Home Department may take necessary decision to amend Rule 23 of the Service Rules 1966 suitably to avoid future complication. This is conveyed as per Finance Establishment Department endorsement dated 2nd 9 2020 and accordingly. Now, one thing, my lord, that so far as that ROP rules, whether at all amendment is required or not required, page 59, my lord, Rule 15. Page 59. This is the ROP rules, my lord. Page 59, my lord has got it.
Yeah.
15, my lord. Overriding effect. In case where pay is regulated under these rules, the provisions of fundamental rules and or any other rule shall not apply to the extent they are inconsistent with the rules. So where is the question of amendment also? Whatever they want to do, amend, you do not amend, the rules are clear. I am entitled. And let an endeavor be made to to hear it at the admission stage, my lord. And if they want to put anything on record,
Does Rule 11 of the revision of pay rule say?
Rule 11 says, my lord, that is at page 58. 58, my lord, if I may read it.
Yeah.
Fixation of pay on promotion on or before 1st January. In case of promotion from one post to a higher post on or after 1st day of January 2006, the fixation of pay of a government employee shall be made in the following manner. A. 1 increment equal to 3% of the sum of the existing pre-promotion pay in the pay band and the grade pay corresponding to the pre-promotion post plus ad hoc fitment benefit, if any, shall be computed and rounded off to the next multiple of rupees 10. I'm covered by
11A.
11(1)A. Yes. 11 read with 15. It is very clear, my lord. In my respectful submission, I do not know what they are waiting for. One department is saying that the other will do. Home Department is still under the impression that the AG needs to do something. Whereas the letter of the Home Department, which I placed at page 64, is very clear.
What instructions you have?
Your Lordship, as my learned senior was saying about the 2021 letter, but my instruction says only till 2019 letter. 2019, we have listened to the AG stating that with regards to this particular pay fixation, to kindly take necessary action for fixation of pay in case of promotion from the post of inspector to the post of APS junior grade as per Rule 2 of the resolution on the report of the Assam Pay Commission 2008 and the report of the committee with the Assam Services Revision of Pay Rules 2010 for all eligible officers. So AG will have to now say who are those eligible officers who are entitled for this pay increment, promotion increment. Now, after that,
The administrative department of the paper that
I understand.
what kind of instructions have you been?
Instructions are only till 2019. Then I have to get the updated instruction and also
You are giving us instructions 2019.
still what I have received, Your Lordship.
When?
This is received on 12/3/2025.
19 instructions you have given.
That's what the instruction says. I have to get the updated instructions then.
And the letter is annexed. It's like a first state of affairs, my lord. And some of the petitioners, they are bedridden, old age, very like.
No, I know. What is
Yes,
what also what?
nothing.
want?
At the present, my lord, some compassion and empathy from them, my lord.
Compassion and empathy.
The instruction that has been received in spite of my annexure 11.
Who is to give you instructions? Mr. Bora, who is to give you instructions?
The Home Department, Administrative Home Aid Department. And I believe the Finance Department also has a say in this particular matter because it relates to pay fixation.
You tell us about you. Who do you represent?
No, yes, I represent the Home Department.
Then why don't you concern yourself with the views of the Home Department instead of
I'll get
trying
the
to
updated instruction.
put it on the shoulders of Finance and Accountant General and everyone else. Your instructions in the first place are not complete. When can you get it?
Your Lordship, 1 week time, maybe then I'll get the
MS is with is for the Bora. Reduce this prayer for further time. Each time. We are fixing the matter on a fixed date. It's on 30. Sorry, 30 would be two short, 7th of May. 7th of May.
I'm grateful.
We'll just come back in 1 minute.
My lord.
Lordship, I am appearing for the respondent number 10 and 11, Lordship, for the bank, my lord. In this case, Lordship, the bank has sought some documents, my lord, from the particular petitioners, my lord, regarding Aadhaar card, life certificate, all those. He is not cooperating, my lord.
These documents with the petition, Lordship.
No, original one, my lord, one depot.
Okay, Lord, I'll inform, Lordship. Retirement benefits, Lordship, on 10.27. No, Lordship. All it is, it should not the bank did not release the money. That's not 10 and
Yes. Yes, my lord. That's one team also deputed, my lord. He sends his residence, then we charge him, my lord, and request him to submit all those, but he is not cooperating, my lord. State Bank, my lord. My lord, this one is Bokahar, my lord. Bokazan branch, my lord.
Bokazan.
Lord, I may be allowed to file the reply also, my lord. In this case, the instruction, my lord, he is not cooperating. My lord.
If I'm appearing on behalf of respondent group 4, on behalf of Beacher, pending counseling. Beacher, Ida. Ida.
Itu protected my lord.
May I please, your lordship. My lord, the petitioner entitled for family pension, my lord, a higher pension, but she has been paid lower pension. Is a my lord covered by division bench judgment, Syed Mohammed Fazlur Rafi, as well as your lordship judgment. Petitioner husband had rendered more than 36 years of service, and she has been paid, my lord, page 63, my lord. My lord, operating part, my lord. That could be space 61, my lord. Otherwise, it will be space 63.
Lord, I'm appearing on the lordship as Dr. Lordship. Please forward to me before Lordship.
Readable, my lord, Syed Mohammed Fazlur Rafi. I have a judgment, my lord, common judge. My lord. Highly obliged, your lord.
Lordship, this is a matter with regards to the repeated transfer of the instant petitioner, and we are currently challenging the validity of this transfer order dated 20/02, 2025. Lordship.
Lordship, the instruction is awaited, Lordship. Some more time will be given. Obliged.
May it please your lordship. Your lordship, my case is that I'm the senior most amongst the eligible candidate in the department. Therefore, I should be promoted to the post of head assistant. Your lordship, in the
Lordship, we had communicated to the department concerned, and the department is seeking for some time to obtain the parawise validity.
my preferred date, lordship. A short date may be a date.
Lordship may give us at least 2 weeks time. We'll do our best. Of May.
Highly obliged.
Much obliged.
My pleasure, Lordship. Lordship, government was directed to file affidavit, Lordship, on last occasion.
Lordship.
I'm paying for 4 weeks time, my lord, for filing affidavit reply against the additional affidavit filed by the respondent 5 minutes.
I'm for proposal.
I does on behalf of the Departmental Health Department.
Great teacher lordship. My lord, in this case, petitioner is denied promotion due to lacking of ACR, my lord. Annexure 4, page 19, my lord, last annexure, but that is uncommunicated. In their affidavit, they have clearly stated, my lord. Kindly see page 31 of their affidavit in opposition. Para 14, my lord, it is not communicated. For the year 2018 and 19, he got 5 points, that is average. And my lord, it's a covered case, my lord. May I pray, my lord, to dispose of the matter, my lord, in the basis of similar and case. Non-communication of ACR, my lord. Yes,
ACR criteria, Lordship. And he has already retired in 2022, Lordship. The performance assessment required is above average, Lordship. For
Maybe, my lord.
2018-19, he has his performance assessment was high average.
Yes.
Yes.
My lord, I will get benefit, my lord. Before retirement, I filed, my lord. And in my restriction, I have told it, my lord. They said that in 2018-19, he got FRS. With my lord, 31, para 14, 22. Ratings are given in para 33, my lord, of 2018-19. Page 33.
Page
Page
31.
31, they have said it is not communicated to me.
Not communicated because it was
And
not
page
advanced entry.
33, my lord, my ACR grading. In 2018-19, he got high virus, that is 5 points. Others, he got 7 points, my lord.
No, Lordship.
The basis of Supreme Court doesn't matter, this order was passed. So I am praying for similar order.
Yes, yes, Lordship.
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 Then 1st of May, my lord, I have some difficult. Next, any date, any date. 3rd, my
Oh, Lordship.
Lordship,
They were to file their affidavit today in the amended writ petition, Lordship, filed by.
Yes, Lordship. Lordship, I have not received my instructions, Lordship. I have not received, Lordship.
Sufficient time has been given to them, Lordship.
May I give a last chance, Lordship.
Lordship, I am praying for curtailment of to increment that has been ordered for removal of that particular order, Lord. And in the earlier writ petition, they have written, earlier affidavit, they have written that it will depend upon the honorable court or the outcome of the decision of the government. That is in their affidavit.
Let it be listed about 3 weeks, Lordship. Last, Lordship.
Enough time has been given to them, Lord.
No, Lordship, when they filed this amended petition in 24 itself.
Yeah, even then, earlier it was 3 weeks time was given, then again 4 weeks time was given, then again
That is
today,
correct,
Lord,
Lordship. Time is given.
for
I am not
3 weeks time.
denying. Yes.
Let it be the last chance, Lord.
No, quickly. No. Thank you.
It will apply.
The matter is already hard. An order was reserved, but it is again coming in admission. Main 2 points are required to be decided. Number one, whether punishment transfer without affording me any chance to contradict or making any inquiry. Transfer permission, punishment transfer is permissible or not. That is to be decided. Not, it may, first may, I don't know whether it will be holiday or not. May, what May? Saturday. May.
Lordship, I am appearing for respond number 2, Lordship. I just want to file one additional affidavit, Lordship. I may kindly be allowed this.
Already they have submitted.
Yes, Lordship. Lordship, I shall. Yes, Lordship. Lordship. I'm respondent number 2, Lordship. Deeply obliged.
For penal. Hello.
My lord, in this matter, I will need further 2 weeks time, my lord. I was supposed to get the record, my lord. Service book and all, my lord. I have communicated. The director writes that needs some time, my lord. 2 weeks. Actually, my lord, for panchayat election, all the officers have been, my lord, deputed for election, my lord. That's the thing, my lord.
Hello, I am without salary from last 15 months.
My lord, he is not in service. What?
Then, my lord, give me the area salaries, my lord. It will be adjusted from my pension, my lord.
My lord, he has retired from.
Without any benefit, my lord. How I am surviving, my lord, for last 15 months.
He has retired from service.
Then, my lord, give me the retirement benefits, my lord. Or area
My lord will pass an order
that
to
will be
give,
adjusted, my lord.
give his retirement benefit, my lord.
No, my lord. I have silenced the retirement notice, my lord. I will be retired in the year 2030, my lord. But they have given the notice in the year 2024, my lord. My lord. They have wrong calculation, my lord. I have annexed my date of birth certificate, my lord. Full certificate I have enclosed. Therefore, I will be retired in the year 2030. And my lord, they have to record. Great.
After 120.
Great.
This matter relates to promotion from junior assistant to senior assistant, Your Lordship. The authority has filed an affidavit, Your Lordship, and the affidavit is transfers, Your Lordship, page 65, Your Lordship, that they have taken a decision to promote the petitioner, Your Lordship, along with one other person, Your Lordship. Page 66, Manjusri Nayak. Page 66, Your Lordship will find petitioner. Fourthly, the managing director placed the name of following junior assistant along with eligibility criteria required to be fulfilled to be promoted to the post of senior assistant. Joy Desmukh, junior assistant, Manjusri Nayak, junior assistant. The members of the committee have gone through the details of the eligibility required to be fulfilled by the above mentioned junior assistant for promotion to the post of senior assistant. During discussion, it was apprised by the managing director of the corporation that as per notification issued by the Government of Assam recently, in order to make recruitment to the post of junior assistant, the qualification of graduation is required. To the above mentioned incumbents possess the qualification HS pass only, they were recruited to the post of junior assistant more prior to the issuance of the government notification. That I have not understood. But still, Your Lordship, they have referred the matter to the government, Your Lordship. Now, it was referred to the government, Your Lordship, on 24th of May 2023. What happened thereafter, Your Lordship, that is not clear from the affidavit, Your Lordship. That's it.
My lord, the thing is that if we go by page 68, my lord, we have stated in our affidavit again that we have forwarded it to the Social Justice and Empowerment. Because, my lord, we get granting aid from Social Justice and Empowerment. The problem is that, my lord, Social Justice and Empowerment is not a party here in this writ petition. Unless, my lord, we did our part, my lord. We have. My lord,
This is the corporation.
I am appear from the corporation, my lord. Scheduled Caste Corporation. My lord, we will come to page 60, para 9. Page 60, my lord, my affidavit, my lord. Para 9, my lord, the second paragraph, my lord. Para 9, my lord, second paragraph. The meeting of selection committee was held on 11/4/23 under the chairperson, sir. The matter of promotion of 14 numbers of employees was placed before the committee. Further, it may be stated that the government of Assam has been providing salary support since the year 2006-7. As such, the recommendation of the committee, along with other related documents relating to the promotion of 14 numbers employees, was submitted to the Department of Social Justice and Empowerment, Government of Assam, for approval by this office letter number such and such, but no instruction from the government is received yet. So, my lord, the thing is that we just, as a board, we recommend, my lord. Ultimately, my lord, it's the government, from there it comes. So, my lord,
And in fact, Your Lordship, if I am, Your Lordship, appointed prior to issuance of this notification by the state government, stipulating a particular qualification, Your Lordship, for appointment to the junior assistant, and I am appointed junior assistant, I was appointed junior assistant much prior to that. Then your requirement at the relevant point of time may higher secondary, Your Lordship. After the notification, they say graduation, Your Lordship. After the notification, Your Lordship. But that cannot bar my promotion. Promotion, Your Lordship, that as such, Your Lordship, they have not stated here, Your Lordship, but I don't have the rule also, Your Lordship. They have a own service rule, your lordship. This is a corporation, your lordship. In fact, autonomous body.
Yes, my lord. That I will produce. But my lord, at the end of the day, social justice empowerment has to be made a party, my lord.
And in fact, your lordship,
My lord, if we go by page 66, totally I'm reading from the middle, my lord. Totally, the managing director places the name of the following junior assistant along with eligible criteria required to be fulfilled to be promoted to the post of senior assistant. So, Manjushri, the petitioner's name is there in number 2. The members of the committee has gone through the details of the requirement to be fulfilled by the above mentioned junior assistant for promotion to the post of senior assistant. During discussion, it was apprised by the managing director of the corporation that, as per the notification issued by the government of Assam recently, in order to make recruitment to the post of junior assistant, a qualification of graduation is required. So the above mentioned incumbent possess the qualification of HS pass only. They were recruited to the post of junior assistant more prior to the issuance of the government notification. After their discussion, the member of the committee decided to forward the matter of promotion of these two incumbents to the government for consideration for their approval in this regard. So, my lord, if I understand from this, my lord, he says that they don't have the qualification. That is why, my lord, we have sent it to the government.
no.
Rule says, my lord, it is graduation. My lord, that rule will say, my lord. I have gone through the rules, my lord. I have the, on the next date, I will bring the rules.
Junior assistant to senior. Senior. Seven. Oblige.
May I please your lordship? Lordship may kindly peruse the last note. It is dated 4/4/2025. Oh,
My lord, there was a, my lord, miscommunication on our part. Actually, we have already filed affidavit. We have filed affidavit, my lord. My friend D. Gogoi appeared. That's why, my lord, on 4/2/25, we have already filed. Prior to that order, my lord, we have filed affidavit. It's a detailed affidavit, and we will argue on that only, my lord. And in fact, they have, petitioner has already, my lord, filed their reply also.
Yeah.
So, my lord, everything is complete. Fixed for hearing, my lord, any day.
lordship, a date for hearing.
Yes, ma'am.
Yes, lordship.
Rule has to be issued.
And lordship kindly fix it. Oh, yes. I'm sorry. Lord. Lordship, if possible, in the month of May, before 15th of May, lordship. Any date, your lordship. June. Lordship. Lord. I'm pleased.
First of all, I have a small submission, my lord. I was not well last few days. I was out of station for treatment, so I could not prepare the brief, my lord. And pleadings complete, my lord. Lordship, and she has filed by order without intimating me, my lord.
It was in
Suddenly-
fact heard and supposed to
suddenly-
pass the judgment, but because of her personal difficulty, it was released. Thereafter, Lordship, it was last listed in the month of January, and already a stay order is in favor of the petitioner, Lordship. He was discharged, but discharge order was stayed. He is had 4 red ink and 1 black ink entry, and thereafter the interim order also, he is not cooperating with the authorities and even creating havoc, Lord. So vacating I have not filed because it was supposed to dispose at the admission stage.
My lord,
That is why, Lordship.
readings complete may be fixed for hearing.
Hearing, Lordship, it's a bit
It
difficult.
will take
because
time, my lord.
Hearing, I have some, because it will take, it will be on a Lordship, at least if she has problem, a fixed date for admission hearing, because there is a direction, admission here. Yes, hearing at the admission stage. No, Lordship.
June, my lord.
No, June, Lordship, because
My lord,
somehow
there is no
after,
such
exactly
urgency.
after 3
My
months,
lord,
I
may
get
I
the
submit,
date.
my lord, one thing? Petitioner is 37 years old. He has served 17 years of service. He is continuing, my lord.
Yes, Lordship.
That's why, my lord, they are in hurry to discharge me.
Can it
But
be
I am
13?
continuing, my lord,
If
without
it is on a
following the
hearing
rule.
day, if Lordship 13th of May, hearing day.
My lord, there are non-ready entries, my lord. There is no such rule, my lord. As soon as he gets the month of June, my lord, I have some difficulty in May, my lord. Any date, June. My lord.
As a fixed item, Lord. For
My
admission
lord.
here.
My okay.
Okay.
Both the matters are analogous. No? In the item of 51, the pleadings is completed. In respect to item of 52, I check up the office note. There is an office note dated 21 of this month, which says that AD card in respect of service of notice upon the response number 4 has not received back. There is an urgency in this matter. I challenge the particular order dated 29 2025. A response number 4 was posted in the post of chief engineer. He is going to be retired by 31st of this month, this year. Or within 31st, the notice was issued on 4/4/2024. I took this step next month. That is why there is a hurry. So can it be, since most probably it is, let it be put on the 1st of May. So in the event, I'll say in the office, directed to in fact, most probably by this time, definitely the idea will be come back. I will check out in the registry also. By 1st of May, definitely something, it may, within the Guwahati, that is why I'm, so let it be on 1st of May. Because I am in a hurry, but he is going to return, the matter will become infructuous. But some problem, let it be remain on the 1st of May, definitely some positive. I will check up in the registry also. Let it, immediately. What happens sometimes, the AD card, somehow it is not connected. That is why I will check up in the registry also. It will be late, because by 31st it will become infructuous.
Malat, highly uplifted. Highly uplifted. Highly uplifted.
PHA.
Phone number 8, simply related to the document number 7 to generate the PPU in effect of the next bit, the PPU. They will disperse the amount, area amount, and to PPO issued to generate issued, my lord. Thereafter, they generate it, and with the help of the disbursing agency, SSB, okay, SBI, they will pay that money.
So let it be then
Yes. That's the matter.